Begin with the next topic, afternoon, which is pari-mutuel wagering, historic horse racing, and local control. And first up, we have Dr. Jeffrey Hammerlink of the University of Wyoming. Sir, would you like to come on up and introduce yourself and I guess tell us what you know, and then we'll go back and forth with questions, sir.
There we go. How's that? Audio all right? Folks online? Okay, great. So my name is Jeff Hammerlink. I am a faculty member at the University of Wyoming. My background is as a land use geographer, community planner, and I do a lot of my work in digital mapping technology and GIS. Just came back from Washington, D.C. this morning where I was talking about national geospatial policy. I can do that often without notes. This I use notes for. I am a member of the American Institute of Certified Planners, and my real experience over the last decade or so has been as a planning educator, teaching community planning concepts to students at UW. And that's sort of where my comments are going to come from today. The LSO staff asked me to join you here, provide a general background on land use planning and regulation, talking maybe specifically a little bit about zoning as a tool. And so I'm happy to do that from a planner's point of view. I think it's important to keep in mind that there are many other perspectives on these topics. For example, from a land use attorney, and I am not a land use attorney, so you're going to get a planner's perspective here. I'll just start a little bit by talking about community planning in general. It's a big topic, and we could talk a lot about it. It's something that's been around a long time, and if I had to define it, sort of modern community planning, you can call it urban planning, city planning, what have you. You know, I would call it a very deliberate political process in a lot of ways, and it's a process for taking community social and economic goals and turning those into policies and programs is really what planning is about. Now, hopefully and ideally, it takes into account the combined interests of individuals or groups of individuals, businesses, and the public at large, and specifically there protecting public health, safety, and welfare. And you hear that a lot in planning conversations. There's a lot of different ways to achieve those goals in planning. It's really, I think, most often combining regulations, for example, zoning being one of those, with incentives, public investments, say, and combining those, you know, with the market system of supply and demand and prices and allowing those things to work together. So carrots and sticks, if you will, a lot of times. You know, planning today isn't just about land use. Oftentimes it deals with public works. We talk a lot lately in this state about housing, transportation, economic development, but all of these things often tie back into land use in a lot of ways. And so I think that's where a lot of this is grounded in the end. In terms of land use planning, it's been around forever. I won't go all the way back, but you can see it in the United States from our very beginning. You know, we've got how New England towns were laid out with a town square. You look at Spanish colonies in Florida and New Mexico. Think about why downtown Denver street grid is set off at the angle that it is from the rest of Denver. Those are all deliberate things. In Wyoming, we could look at the settlement pattern in Star Valley and how that grew out of ideas with the settlement of Salt Lake and the Latter-day Saints and their sort of land use pattern that they put in place, right? So planning is a very deliberate thing, and we've been doing it for a long time. And we can see that on the ground, right? And that's an important thing because people see what's happening at a particular place, and they see that use, and they understand how that might, or maybe don't understand, how that might impact them or not impact them, right? And so again, it's this kind of combination of government and the market and individuals that shape how land is developed and used. Most authority for doing land use regulation is at the state and local level. That comes through the 10th Amendment of the U.S. Constitution. and through state enabling legislation that guides a lot of local regulations and policies. So because of that, there's a lot of players involved, right? There's elected officials, there's people that are appointed by elected officials to work on these things. There are expert advisors like professional planners and attorneys, many of whom are in the room behind me. I think it's also important to realize that land use planning isn't just about cities all the time. It isn't always about what happens inside a municipal boundary. And in fact, different rules usually apply depending on if you're inside a city boundary governed by, say, a city council, or in an unincorporated area overseen by county commissioners. So in Wyoming, local land use planning occurs at both the county and municipal levels. I kind of think of it as consisting of three major components. One is about land use and its related infrastructure, utilities, transportation, roads, and so forth. Services, whether that's services for public safety, education, public health, recreation. And then the third one is around land development and how we go about doing things like subdivisions and developing new land, whether that's inside cities or outside. As far as county planning goes, this is authorized in Title 18 of the state statutes, Chapter 5. Under that chapter, the Board of County Commissioners has the power to regulate and restrict the location and use of buildings and structures and use, the condition of use or occupancy of those lands for various uses, from residential use to agriculture, industry, and so on. In order to carry this out, the commissioners have the power to create a planning and zoning commission. If they decide to establish a planning and zoning commission, then that commission is afforded the power to develop a comprehensive plan that addresses these things that I was just talking about and make recommendations for planning and zoning in the county. As required by law, all 23 counties have adopted a comprehensive plan or land use plan, which isn't always necessarily exactly the same thing. But not all counties in Wyoming utilize zoning as a tool. They don't all utilize it. As far as cities go, that's Title 15 in the state statutes. Under Article 5 in Chapter 1 of Title 15, cities and towns are granted the authority to establish a planning commission. As with the county planning authority, municipalities may have a planning commission but are not required to. However, if they do create a commission, they're required to adopt a master plan for the community, and that would include zoning, a zoning plan aspect of that. So that's kind of the big overview of this. Talk a little bit about zoning. Zoning is probably the broadest of land use control tools or techniques that there are out there. And it has been applied to virtually any private use of land and a lot of public uses of land within zone jurisdictions as well. Not just in Wyoming, but kind of across the board. How would you define it? One definition is it's a regulatory tool. It's a regulatory method for controlling land use that establishes districts or zones, hence the name, in a city or county to regulate specific uses and characteristics. So uses being tied to different categories like residential, commercial, industrial, and so forth. And also determining which land uses are permitted or prohibited in a particular zone. Zoning's not new. Zoning's been around for 109 years in the United States anyway. The first zoning regulation, 1916 in New York City. But the beginnings of it were way before that, in big cities dealing with health, safety, welfare, protection of property related to congestion and overcrowding. We don't maybe have those same kinds of issues as faced by a place like New York City 100 and some years ago. But the tool of zoning and after it had been introduced led to fairly widespread interest across the country in using this as a tool. And that led through the U.S. Department of Commerce in 1924, publishing the Standard State Zoning Enabling Act. So really put a template out there that states could use to do this kind of work. Of course, it went to court, and in 1926, the validity of zoning, if you will, was affirmed in Euclid versus Amber Realty. And that's kind of a key legal precedent that really affirmed the idea of zoning. So I share that because very quickly after that, a lot of states moved to adopt zoning. And Wyoming was no exception. And so really, a lot of this in a lot of states, whether in the eastern U.S. or the western U.S., were driven by this. And so we have that enabling legislation, as I said, for counties in Title 18 and cities in Title 15. So how do you actually implement zoning? and how do you talk about this and explain it to somebody? I kind of think of it as like there's three parts to this. We all think of a zoning map, right? And we see that map and it has different colors for different categories of use, and those are standardized now. So yellow means one thing and red and blue and so on. And what that zoning map does is it delineates zones across a city or county that specifies allowable uses and development characteristics. And that's just the map, right? That's just sort of where are these zones located. The second part of it is the zoning ordinance itself, or the zoning document, if you will. And what that does is it's the narrative that lists and describes permitted uses in each of those zones. Along with that are this idea of restrictions or requirements related to development. So think of this zoning map, right? Residential, commercial, what have you. It's simplifying it greatly. Maybe it's sitting on top of a parcel map that shows parcels within a city, right? You go and you take one of those parcels and you look at it and you say, I want to put a house there, okay? And so you can sort of think of the other part of the zoning document as saying, okay, I'm going to put a box right on top of that parcel. And I'm going to have some rules about what can happen inside that box if I'm going to build on it. It might be related to access to that structure. It might be related to building height. It might be related to how far it has to be set back from the street, how close or not close to the side property line, those kinds of things, right? So that goes hand in hand. So you've got the map and you got the document. And then along with that, you have something that is really the procedures for how you go about amending this stuff, right? Because these things are not static. Like, these things can change all the time, and they can. An important thing maybe here to note is that the map can change without changing the definitions of a particular zone. And the definitions of the zone can change without necessarily changing the map. So they don't always go hand in hand, and sometimes people don't realize that. Just a little bit more, and then I'll stop. Zoning has evolved over time. Now there are some regulations that vary by specific use across zones. Parking is a good example, right? As the automobile became a bigger part of land use. So that is one change. Sometimes now we talk about performance zoning, where you're doing zoning based on a development meeting certain metrics, rather than having to follow a strict kind of a definition for a particular zone. And if you can meet some threshold or meet some metric, whether it's related to noise levels or what have you, that would be an example of something called performance zoning. A lot of times those things are incorporated into traditional zoning as well, so you have kind of a hybrid sort of a way of doing this. Another type of zoning is an overlay zone that you can do. So probably the most common one of these would be like a floodplain zone, where you have special regulations related to what you can and can't do in a floodplain. So it's usually based on where you're at, kind of the geography of that place, whether you're in the floodplain or not. Zoning isn't without its problems. It's been misused in some case. Sometimes it's used to exclude things. Sometimes it's used to advance certain things over another. So sometimes zoning has been used to restrict or ban things like apartments or other kinds of affordable housing. Sometimes it's put in large lot requirements to raise the values of buildings. Sometimes there's been excessive zoning done to promote non-residential use to bump the property tax potential up. And those have all been contested. And they're, they are ways that zoning have been misused. Couple other things I would say, maybe two criticisms that come up sometimes now about zoning is that sometimes zoning is too complicated. That sometimes it's really hard to understand the regulations because they've grown so much over time. And with subcategories of zones and different things like that. And so that has been a concern that planners and attorneys and elected officials have tried to look at. The other one is around fairness, and that if you sort of zone at too fine a level for a very fine particular use, that does raise questions of, are you singling out a particular type of use and whether that's appropriate or not, moving away from, having more general broad categories. I guess with that though, I might end that, I think a lot of times in the news, zoning is viewed as this kind of zero-sum game between government and developers. Either one side wins or the other. That I don't think that is ever the intent, the good faith intent with a tool like this. I think on the government side, it's really trying to balance the will of the people, if you will. What they're hearing from the community, the kinds of planning goals that as a professional planners would hope for a healthy city, and good governance, that everybody has a voice. And so kind of looking at a tool like this and how it might apply to whatever issue you happen to be looking at, I think we want zoning and other regulatory tools to be, we want it to be effective, we want it to be fair, we want it to be efficient and understandable, right? So we don't get bogged down. But also, while we want it to be flexible, we also want it to be predictable. So that there's some predictability if you're going to be flexible and think about, variances and different things like that. So maybe I'll just stop there, and I'm happy to try to answer any questions, or if that's given you enough background, happy to step away from the mic as well.
Thank you, Doctor. Representative Johnson?
Thank you, Mr. Chairman, and thank you, Dr. Hammerlich. Is that correct? Tell me the difference between a SOB and an OTB. You would zone both of them different. You wouldn't zone them differently, would you? I mean, why would one be different than the other? Is still a viable option?
I mean, I think, and I am not an expert on this, and I'm not sure I'm qualified to answer that question without a little bit more research on my part. There are probably others in the room that could, in the experience of their jurisdictions. I think they share some. I think they're the types of land uses that might share some of the same concerns from community members, but also different in that just in terms of they're going to vary in terms of potentially vary in terms of hours of operation and traffic and different kinds of activities like that. And I think the important thing is to kind of suss that out and look at how they're different. That's probably as far as I'd like to go on talking about that.
Thank you, Doctor. Co-chair on the line.
Thank you, Mr. Chairman. Thank you for coming today, Mr. Hammerlink. Would it be fair to say that zoning is helping the local authorities to tell the businesses where to go, how big to be, and when their hours of operation are?
I mean, I think it does serve that purpose of providing that kind of guidance and sideboards around that. I mean, development is best done in a partnership, right? And so, a key part of that and kind of getting to this idea of, efficiency and understand, being able to grasp and understand these regulations. I think that's an important part of it because it oftentimes does end up being a conversation, if not a negotiation.
Follow-up.
And I will say, there are other types of tools that are even more, a matter of negotiation in a lot of sense. I didn't talk about planned unit developments and how that's slightly different than zoning. I'm not sure it would really apply to the issue that you're talking about here, but yeah, these are really guidelines and sideboards for developers.
Thank you. My follow-up question would be, if you're familiar with nonconformity clauses, could you speak a little bit to that?
And I do have some more notes here, so let me. I mean, really, the thing with a non-conforming use is when you have a use that does not conform to whatever that, excuse me, zoning regulation is or becomes, right? But if a zoning regulation is amended in such a way, or the definition of allowable uses for a zone is amended in such a way, and that non-conforming use is already there and in operation, my experience has been that those non-conforming uses are grandfathered in if they're continuing on in their current use.
Follow-up.
Thank you, Mr. Chairman. One more point that I would like you to speak about, if you're familiar with it, would be a takings. Could you just inform the committee on what a zoning taking may include?
Yeah, I mean, in a nutshell, and I should probably have some notes so I get it right, but it's really a taking away of property rights without just compensation.
Thank you, Doctor. Senator McEwen?
Thank you, Mr. Chairman. It's a broad question here. So, do you think the government should be involved in zoning? And how much are the people who have to live with zoning involved? And I do have a follow-up after that.
Sure. It is a broad question. There's probably a wide range of opinions about this. Well, I think that, first of all, the constitutionality of zoning as a tool across a wide range of situations has been upheld. And so maybe some folks would think that's a question. Most, I would say, don't think that's a question. I think, though, that zoning and enforcing zoning starts with good planning. And that means engagement and participation by the citizenry. And if you don't have that, it doesn't really matter what regulatory tools you might apply. I think you're missing that will of the public if you don't have a valid participation process.
There's a follow-up question, Senator.
Thank you, Mr. Chairman. So what you're saying is we basically belong to a democracy and not a republic. And whatever anybody else wants Like if in my neighborhood, Billy needs a bike and Joey gets a bike and everybody in the neighborhood decides Joey needs a bike, Joey gets the bike. Kind of the difference between a Republican and democracy. So my question is, and I go back to what I asked you, do you think the government needs to be involved in this? Thank you, Mr. Chairman.
Doctor?
I mean, I think tools like zoning came about, again, kind of going back to this idea of the protection of public health, safety, and welfare. And that's very much a yardstick, I would say, in terms of the degree to which regulations like zoning are developed and applied. Prior to zoning, we had something that was called nuisance law. And so, in very simplistic terms, maybe, folks did what they wanted to until, say, somebody complained or got sick or or their safety was at risk, and then government would respond to those things, right? And that's been established for hundreds of years, not just in the U.S., but in Europe as well. I think the shift with a tool like zoning is to be able to be put more forethought into that and be proactive rather than reactive in a lot of ways. I mean, that was the major shift, 100 years ago with zoning.
Thank you, Doctor.
One last question, Mr. Chairman, and then I'll be quiet.
All right, Senator McEwen, please go ahead.
So I kind of equate zoning laws to all the COVID stuff we have to live through. Once again, run by the government. My question is, do you think the government should be involved in zoning or not? Thank you, Mr. Chairman.
I think just very, very generally, in cases of protecting the public's health, safety, and welfare, there is justification for land use regulation and zoning.
Thank you, Doctor. So it is, Doctor, public safety. I mean, back in the day when I was a county commissioner, that's really what we hung our hat on. Public safety, those type of issues was something really undeniable that we were charged with oversight over. And sometimes it did involve, disputes amongst different landowners, which my joke always has been that the disputes were because you had a bad neighbor, and the bad neighbor was doing things you didn't like. So you, like you said, it used to be complaint driven, and kind of still is though. And then we try to deal with it so people have a reasonable expectation of development they can do on that said property they purchased. So my other question would be is, what do you do when you're making a change? I mean, we talked about the taking a little bit, but you bought a piece of property, zoned a certain way, let's say, with a certain expectation with that property that you purchased. And then in the future, one way, whatever happens, it changed, right? And so it substantially changes to stop your use that you bought it for, in this case. Well, I mean, there's other mechanisms that we have either. So I think the change that I'm talking about goes both ways, right? You bought a piece of property and now they've made the zoning more onerous towards you, or they made the zoning more laxed. I guess you can do whatever you want to do. But when there's more requirements to that zoning, what does that property owner do at that point in time? I mean, I think if you'd explain to everybody that how long that right exists that you had before the property zone changed, who has that right? How long do they keep it for? And then if that right had changed through whatever mechanism, then would that same still thing apply with say there was a referendum with a vote and the use changed that you intended it for, and you got folks that purchased it under the circumstances of, of that zoning at the time. And then, of course, that use changed. So I'm talking kind of about two different things. But the question is just what do you do in a practical sense when you have a set zoning and then said zoning changed? Could you kind of help the committee out, task force, with this?
I can try to the degree that I have an understanding of it. I mean, in my mind there, what you are talking about is that then you have created a non-conforming use for that particular property, those particular sets of properties. And again, in my experience and understanding, that as long as those continue on in that particular use, that they would be allowable as a non-conforming use. Say that business closes or that property is sold or what have you, then that gets a little bit more complicated. And I would have to go back and I would want to research that answer a little bit. And I think it varies by place and situation and the type of change that had happened to the amendment. I think, though, another externality or impact of that change in use that a business owner might be concerned about related to that non-conforming use is if they feel that it results in some type of taking, right? And again, probably better addressed by a land use attorney, but then you're getting into whether or not that property owner can realize the value of their property based on that change in use.
Thank you, Doctor. Coach Shyline.
Thank you, Mr. Chairman. I believe what we were referring to is a vested permit, if I'm not wrong, that allows the property owner to continue to use that property in that manner until a change occurs in ownership, and then that property right would then be deemed the new zoning law, if I'm not mistaken.
Thank you. That is the term, yes. Another thing I would say about non-conforming use, a lot of people, think that, with zoning changes and whatnot, and redevelopment, say, of downtowns or what have you, that non-conforming uses are just going to go away instantly. And the reality is that they're not. Non-conforming uses will be around, and that's sort of the nature of these kinds of changes and the ability of those property owners to continue to exist with that vested right.
Thank you, Doctor. Representative Johnson.
Thank you, Mr. Chairman. I live here in Laramie County. There's a lot of development going on, and I see these signs. They're going to change zoning, and they have to have public notice, and the public has the right to testify about the zoning changes. I mean, these things happen all the time. Is that correct? I just want to make that straight. Most businesses, when they move in, it seems like they get a zoning change anyway. The majority of them, so if you could address that.
I mean, yes, these things, if you, when you apply for a building permit or to add on to your home or build a fence or repair your sidewalk, these kinds of things, depending on the community, depending on exactly what the regulations are. I mean, those signs that you see, can include examples like that. And those aren't zoning changes. Those are just development permits, not just, but different category of regulatory tool.
So you say those aren't zoning changes, right?
Well, the example, excuse me, I didn't mean to interrupt you.
Go ahead. I think
I was just responding to the example that you gave, that is not a change in permissible uses in that particular zone. So that would tend to fall under development code and building code, which are two of the many other categories of regulatory tools that can be used in land use planning.
Thank you, Doctor, for that clarification. Coach Shyline.
Thank you, Mr. Chairman. Mr. Hammerlink, I just wanted to thank you for your paper that you wrote or co-authored from the University of Wyoming. That was a great tool for me to be able to wrap my head around and gave me some great references for materials to start reading on my own about zoning. So I just wanted to thank you for your work and coming today.
You're welcome.
Further questions for the doctor? I don't see any. Well, doctor, thank you again for coming in. And if you want to stay around, I guess you made the trip over here from Laramie and came back from DC, which has to be better than DC. So you're more than welcome to stay, and maybe there might be a question coming up. And once again, thank you for coming in and testifying.
It was my pleasure. Thanks.
Camera, I think you're up. Consider draft legislation. Then we'll discuss this draft legislation. Everybody is in the audience about zoning as soon as we get the bill presented in front of us. And then we'll take testimony on public comment.
Thank you, Mr. Chairman. I appreciate that background. As we go into this next bill draft, which does bring in an element of local zoning authority, and that background will help us look at that element as it relates to gaming establishments and specifically pari-mutuel wagering, off-track betting, the simulcasting gaming establishment. So at your August meeting, you directed staff to prepare a new bill draft to use local zoning authority as the authority to regulate simulcasting and historic horse racing facilities. So we're only talking about the simulcasting permit holders, not racetracks, not skill-based amusement games or other types of gambling, just the simulcasting and historic horse racing facilities. You also asked that this bill draft include two other aspects. First, to create a max on the number of terminals, the video terminals or machines, and to tie that number of the maximum to the number of racetracks live races are run on for the operator, and then to prohibit authorization of new terminals until the existing terminals are put in use or they're withdrawn. The bill draft is 26 LSO 168. It reflects that direction somewhat. The concept of regulating simulcasting through zoning was a little bit of a broad concept as it came in at the last meeting, and so this bill draft might not have gotten it quite right, but it brings in some aspects you can read through and discuss whether that's how you intended that to look. Big picture, the zoning authority is something that city, towns, and counties are expressly authorized to regulate, and specifically the citing of simulcasting pari-mutuel wagering facilities through zoning in this bill draft. Nothing in existing law prohibits city, towns, or counties from passing zoning ordinances that relate to simulcasting broadly, but this bill draft would make it explicit. Now, keep in mind that as opposed to the other bill draft that we will consider later today and that we considered at the last meeting, when you have something like licensing for liquor licenses, or you have a condition precedent that a local authority approve before licensing is granted, that's about deciding whether a specific applicant is or should be suitable to hold a permit and whether the operation they propose is suitable for that community. Zoning, by contrast, is about where that business can be located in the community and under what land use conditions it must operate. So they're fairly different tools that you'll see here in 26 LSO 168 and in your next bill draft for consideration. They can be worked together. For example, liquor licensing, there's a zoning aspect as well as a licensing aspect that locals have, or as is presented to you here, they are sort of alternate, policy alternates, and we could work them together. There just would need to be some conforming if that's desired. Then, as I said, big picture on this bill was to create some caps on the wagering terminals. So I'll jump into it now and point out where each of those provisions come in. It's working draft 0.5, titled Pari-mutuel Simulcasting Amendments. Section, amendments begin on page 2. The changes come in within the definitions or within the pari-mutuel statutes. And within the definitions, simulcasting is defined This would make a conforming change first on page 2, line 10, to just clarify that the commission shall authorize simulcasting subject to this provision that's later in the bill draft and the following conditions. This is an existing condition, and the existing condition is that simulcasting may be conducted off the permitted premises of a live parimutuel event only if the applicant submits evidence to the commission that the simulcasting facility and operations comply with all applicable local zoning regulations as required by the local government where the facility will be located. Further, an applicant demonstrates compliance with this subparagraph as a matter of law if no applicable local zoning regulation exists. This changes the status quo, yes.
Yeah, Tamara, I'll stop you right there. I got a question about that. Explain how that fits together. I'm a bit, if there's no local zoning, and then that last paragraph you just read, how does that work? I mean, structurally, how would that work? Let's say there is no zoning, right? That's what we're contemplating now, because some counties don't have zoning. So then what does that mean? I mean, what exactly does that allow the locality to do in that circumstance when there is no zoning? Could you help me out with that?
Sure, Mr. Chairman, thank you. If there is no zoning in that locality, the applicant would simply include in their application that there's no zoning authority that's applicable to them, and this criteria, there would be nothing further that they would need to do on that. The local community would have no say other than to reenact their zoning regulations or to amend their zoning regulations to address how simulcasting facilities can be, where they can be located, and put conditional use on their locations and their uses.
So just to follow up with that, then this does not apply to them, right? Because there is no zoning. So half the counties in our state without zoning currently, right? This wouldn't apply, just to be clear.
Yes, that's correct, Mr.
Okay.
Chairman.
Well,
There'd be
thank you.
nothing other than we've checked this box. There's nothing that applies to us. But what you are doing on lines 15 and 16 of page 2 is changing the status quo. Right now, the Board of County Commissioners of the county in which the simulcasting will be conducted must grant it approval, its original initial approval that can't be revoked. It must grant that. This would repeal that and to substitute in that just compliance with local zoning regulations, if there are any.
Well, basically, okay. Thank you for the clarification.
On page 3 is a little bit of technical changing to work in the new limitations or the caps on machines that would be operated. Within subsection M states, with respect to simulcasting permits, the commission shall adopt rules to, and this is existing law, just cleaning it up so it fits with this new requirements we're putting in. First, to establish the number of actual live horse racing or parimutuel event days required to qualify for a simulcasting permit. We strike some language for technical purposes, just to not reiterate the same thing twice, and state that the rules shall ensure fair and equitable involvement of all affected parties. Then a new requirement in paragraph 2, the commission shall adopt rules to specify requirements for parimutuel wagering terminals operated under a simulcasting permit, including all of the following. So adopt rules for the machines, the terminals. A is that no applicant shall be authorized to operate additional parimutuel wagering terminals at any location in the state if the applicant is authorized under a simulcasting permit to operate one or more parimutuel wagering terminal at any location in the state that is not in use. So when they go to apply for a parimutuel wagering terminal, if they have any in the state that are not in use, they would not be granted a new one. This was the request that no new terminals be licensed unless all terminals for which there was approval be put in use. I envision that they could also ask the Gaming Commission to retract approval for existing terminals if they find that they're at a location and they don't want to build that out. Subparagraph B puts in the cap. A permit holder shall not operate more than 1,200 parimutuel wagering terminals in the state for each permitted live flat track on which the permit holder conducts a live horse race or other parimutuel event that qualifies for one of their live days. Those are the two provisions that relate to.
Excuse me, Tamara, we have a question. Co-Chair Line.
I apologize, I didn't mean to interrupt your thought. Thank you, Mr. Chairman. My question is, where I'm reading where we strike the live horse race days, is there somewhere else in statute that it also ties it to the track days, or are we getting rid of the live track requirement altogether?
Thank you, Mr. Chairman. And Madam Chairman, that's a great question. It was slightly redundant in the way that it was written. It started out with on line 9, the commission shall adopt rules to establish the number of actual live horse racing or parimutuel event days required to qualify for a simulcasting permit. That still exists. That was just repeated. The commission shall adopt rules, which we've now moved above to subsection M on line 7 above. The commission shall adopt rules governing the establishment of live horse racing or parimutuel event days required for a simulcasting permit in a manner that ensures, I think they were just technically saying the same thing twice. Through the structure, it's changed. The number of actual live horse racing or parimutuel event days required to qualify is still in the law here. Then moving on through the statutes on page 4 and line 5, this is the existing law for all parimutuel permits. They shall be for a period not to exceed 3 years from the date of issuance and have been approved by the Board of County Commissioners and provide a bond acceptable to the commission. Because this bill draft is moving the regulatory tool from a approval by a county to zoning by a city, town, or county, an exception is made there on page 5, line 1, to clarify that approval by the Board of County Commissioners is not required for the issuance of simulcasting parimutuel permits. Again, that's just leaving it to the zoning, any zoning regulations that exist, to the extent they exist. On page 6, we're still within the parimutuel statutes. This is the part about voting, that no parimutuel event may be held in a county until the question has been put to the people of the county, whether they want to accept or reject that. This adds in a new subsection B to specifically spell out that a county, if they do decide to have allow parimutuel wagering, the governing body under their existing zoning authority, which is 151601 through 151611 for cities and towns, or the Board of County Commissioners under their existing authority of 185201 through 185207, they may regulate and restrict buildings and structures and the use, condition of use, or occupancy of land operated as a simulcasting parimutuel wagering facility. This is somewhat unique in that most statutes do not direct the specific zoning or permit the specific zoning for a type. It's just usually falls under the general police powers of a city, town, or county to regulate the health, welfare, and safety of the public. So this is a very specific call out to say that local governments can use zoning to regulate the land use of facilities used as a simulcasting wagering facility. Then subsection C on the bottom of page 6 is an interesting concept to Wyoming statutes that hasn't been used to a great extent, or I don't believe it's ever been challenged in court under the Wyoming Supreme Court. But it's the concept of how to terminate a non-conforming use. And the issue is somewhat of timing and somewhat with the nature of zoning itself. Uses of lands develop, gaming establishments open and other businesses open, and then zoning regulation might come later when rezoning or communities change or develop, and the use of a certain area is no longer in conformance with the zoning regulations. That's generally a non-conforming use, as you just heard, and as I think you probably will understand. And there's a general right under Wyoming statutes and the Wyoming Constitution to continue your non-conforming use of a property that you've established before the zoning regulation was adopted.
Tamara, question. So this is, to me, a clear taking, okay? I mean, to me, it's a clear taking to state this, to say that no compensation, you must cease the activity you were involved with because I said so. I understand, from what I understand with the state of Wyoming, it goes against our Constitution unless there's a constitutional amendment that would allow us to do that. That's what I heard the out was. But this, on the face of it, is a taking. I mean, I guess, I realize where we're at here, but on the face of it, I don't know how legally do we do this without going to court on the issue of a taking? I mean, do you foresee legal consequences for enacting, let's just say just made it through the whole process, and you got a person who then was told you can't do whatever you're doing, and basically you devalued their property rights? Wouldn't they have some standing to go to court and appeal their case? Maybe that's my thought. What do you think? Do they have a grounds to go to court to appeal their case?
Thank you, Mr. Chairman. And that is a great question, and a big crux of the issue here with subsection C that we'll want to be very clear about how it might play out. And I guess let me just explain it first. This concept is called amortization, and it's one of the ways that, not as used in Wyoming, but one of the ways that states have developed to cease a non-conforming use. Other ways include, you grandfather in the non-conforming use, but if it can't be improved upon, you're kind of stuck with what you have, or if you abandon it, then the use is gone. But this is amortization, and what it says is that amortization would be allowed through zoning facilities. A city, town, or county could say that, for instance, simulcasting facilities are not allowed in this zone, or they're not allowed within some certain feet of a school, and that happens to affect an existing zone, an existing business or facility. What is included on page 7 is saying that the local zoning regulation, if they decide to terminate that non-conforming use, there must be a reasonable period in which the non-conforming use shall be required to cease that allows for the recovery or amortization of the investment in the non-conforming use. This isn't a payment, this isn't just compensation, but this is saying maybe it has to stay open for 40 years for the useful life of the building. It would be up to the city, town, or county, and this would be specific authority, because statute currently says you cannot do this in any kind of zoning application, but this would be up to the specific local authority to decide to use amortization as a tool to rezone areas to exclude simulcasting wagering facilities. Now, an applicant or a business owner, landowner who this could happen to certainly would probably want to raise that as a takings issue under the Fifth Amendment and under Article 1, Section 33 of the Wyoming Constitution, and undertakings, jurisprudence under the federal Constitution. It's a question, but Wyoming's Constitution is rather strong on this too. It provides that private property shall not be taken or damaged for public or private use without just compensation. It's generally takings that are, actually taking the property and using it for something else, or diminishing a property right is considered a regulatory taking. And yes, there would be a possibility, I would foresee it'd be very likely that somebody this might happen to would try to pursue recourse if they want to continue operating where they are operating currently. And that recourse would be against the city, town, or county and the local zoning ordinance and how they structure that amortization and how fair it is. The only thing that I found that we have in statute that sort of matches was a provision relating to, I believe, feedlots, and it still wasn't structured quite this way. This amortization of nonconforming uses is something that other cities, towns, and counties across the United States have used and other states have used, and their courts, I'm not sure it's 50-50, but I think it's a majority of the courts have allowed for amortization and when there's justification for it. But some cases, some courts have not found it. And we don't know the outcome in Wyoming, and I can't predict how they'd go for it, but you are exactly right that there is a long history of strong private property rights. It's typically used for things like adult entertainment establishments, or it's become more useful in states that have legalized cannabis, things like that, where the buildings started happening, the use started happening before the zoning regulations could be adopted. And so now the cities and towns and counties want to get a grasp on some of that and those uses, and they are challenged because the buildings already exist and the businesses are already there. So this is one of the tools that is used in other states.
Just to follow up with that, so in the state of Wyoming, has this type of language ever been tried to be used, or is it in any way, shape, or form currently in law that this is a process that we could affect this end, this amortization in this case, which is compensation, really, in a way, it's compensation, but not monetarily, apparently. So in the state of Wyoming, is there any history to this? And then, I think you said no, but, and then surrounding states, have you other states that do this, that are adjoining states? Do we know of those states? What other states are currently doing?
Sure.
And if you don't have the answer, Tamara, you can get back to us, but I just wondered if you knew.
Thank you. I will say there's nothing like this in Wyoming statute currently. I think there might have been, there might be some smaller examples of amortization through local ordinances, but nothing at the state level in this way. I don't know all surrounding states. I will have to get back to you on this. I know Texas and Colorado and some other states that I've looked at, they've had aspects of amortization in certain instances, and it's usually for specific businesses. It's not a wide-scale tool that's used to allow businesses to be, for their non-conforming use to be ceased. It's usually for some kind of a business that they're trying to change how it exists in their city for some reason that they believe relates to the public health, safety, and welfare.
All right, well, thank you for your explanation. Continue.
Then on page 7, beginning on line 7, you're within 18.5207, which is in the county's authority. This is the provision on the continuation of existing use. And this sort of reiterates the Constitution and the concept of existing right, in that a zoning resolution enacted under these statutes shall not prohibit the continuance of the use of any land, building, or structure for the purpose for which the land, building, or structure is used at the time of the resolution is adopted, except as provided in Wyoming Statute 1125-206B and C, which was just on page 6. This is the general provision that this type of thing is not allowed, and here would be a conforming exception for counties. The city's authority doesn't specifically say that, so I did not add in a exception there. Then on to page 8, section 2 is to direct the Gaming Commission to promulgate rules necessary to implement this act. Again, the caps on terminals will require rules. It's a broad direction to the Gaming Authority to promulgate those rules on how to define those limits within the parameters of statute, the tying 1,200 to a racetrack, and not allowing for new terminals when there's existing ones licensed. Section 3 is the applicability clause. It would affect existing permit holders, until the expiration of the term of their permit, they'd be subject to the original conditions and of their original permit. And then upon renewal, the requirements of this act, including any applicable rule or local zoning regulation, would apply to them as applicable. Section 4 is a split effective date, simply because Section 2 asks for rules. This would allow the Gaming Commission to start on the rules right away, and then the entire thing would go into effect July 1st, 2026.
All right, thank you, Tamara. Questions? Task Force, Co-Chair Line?
Thank you, Mr. Chairman. Thank you for putting this legislation together. If this may be a director question, but could you remind me, in the permitting process, they come before you every 3 years, or is it that a terminal, once it's permitted, only comes out of commission if there is a discrepancy within the company operating it?
Thank you, Chairman Cole. Madam Chair, so they're re-permitted every 1, 2, 3 years. We review them. If the operator puts in for a 1-year permit, they're reviewed every 1 year. If it's a 3-year or 2-year permit, we would re-review them every 2 or 3 years.
Thank you, Director. Tamara, I did have a question about this Board of County Commissioners not having a say-so in the permit approval in this application. But isn't it true, though, the Board of County Commissioners can just rezone? And then once they rezone, they would, in fact, exercise that said control if they so chose to? So in fact, they do have power to do exactly what this says they can't do. And I guess, is that a conflict at any level? You follow what the circumstances I'm laying out, I guess my scenario?
I'll have you repeat the scenario. I don't
So
think I'm
we
tracking.
got the Board of County Commissioners that does in fact implement zoning, right? And by that implementation of zoning, they in fact have restricted. In some cases, let's just say they've rezoned and they've chosen to do it in a way that really doesn't have any zone districts for gaming, right? So then they go in for an application, for a permit application, right, through this proposed process here. And they, by their action of zoning the way they did, in fact exclude or they include a zone district for gaming, right? So they do at the end of the day through a zoning process have some say-so in the outcome of that zoning process while it applies to the county. And I suppose the city would be the same situation. Wouldn't that be true?
Mr. Chairman, I think that's right, that if a county or city decides to zone, if they do zoning and they decide to zone in a way that restricts, that prohibits all uses as a simulcasting facility, and there are none that are in that zone, there are none currently operating in their county, then when one tries to come in and they try to apply to the Gaming Commission under this bill draft, they can't demonstrate compliance with local zoning ordinances because local zoning says they may not operate. And that's every single applicant that might want to apply. They would not be able to, no businesses, period. It doesn't matter who's operating them. They're not allowed per the zoning regulations. I don't know of any counties or cities and towns that have that kind of specific zoning regulations for simulcasting facilities. And maybe there'll be public comment on whether that is something that they could conceivably think they could pass or that they would pass. I think that it is changing the condition precedent where under existing law, the Board of County Commissioners must approve an explicit licensee. So somebody who's applying to work in that county, to operate a facility in that county, current law says the Board of County Commissioners must approve that. And this is striking that and changing it to zoning.
All right, thank you for the explanation. I think there's some other situations where we could have unelected people be involved with zone districts. Some counties have a different policy where basically their non-elected folks could make that decision. I think in the cities that exists. So it concerns me that we would dare have unelected people make zoning decisions. That bothers me to no end because they weren't elected by the people. I think Cheyenne was one of the places that they were complaining about said zoning change. I think they call it a board of adjustment. Maybe I have that wrong, but there's an unelected group that are put into office for this purpose. Okay. Well, thank you for the explanation. Co-Chairman Line, you have a question?
Thank you, Mr. Chairman. Thank you for all of your due diligence on this. When we come back to page 2, when we remove that control from the county commissioners, is it fair to say that this levels the amount of control between municipalities and counties because the Wyoming Gaming Commission would be doing the permitting of the who, but their zoning would take care of the how, when, and where?
Mr. Chairman and Madam Chairman, thank you for the question. I don't know if they would see it that way, whether the differences in the actual level of zoning that is adopted by cities and counties and towns, whether they think that it would be level between them, but it does, right now, it is fairly one-sided in that the Board of County Commissioners is the only thing that's in statute. And right now, it does bring in city, towns, or county, whoever chooses to zone, and whoever would be zoned, whose zoning regulations would be applicable to that specific establishment. So depending on whether it's going to operate in a town or in the unincorporated areas of the county would be where the applicable zoning regulations come into play.
Thank you, Tamara. Any further questions from the task force? Seeing none, Tamara, this is obviously going to be going on for here for a little bit, so please stand by. Nick, would you have a comment about this proposed legislation?
Thank you, Chairman Kolb. I just bring your attention quickly to page number 4, lines 1 through 6, where it discusses the applicants, the build-outs. No more terminals can be approved until they're all in use. I just want to give you some current numbers just so you can see what that would be as of today. So currently, maybe, there we go. So currently, one of our operators has been approved for 2,310 terminals. And of that 2,310, they have 1,146 in operation. Roughly 50% of their approved terminals are in use. I would note on this one that 757 of those terminals have been approved for a large border site build-out that's being built. So that's one of the reasons why there's that big difference in those numbers. One of the other operators has been approved for 2,804 terminals. They're currently utilizing 1,052, or 38% of their approved terminals. This one is also, they actually have roughly 1,700 terminals have been approved for 2 border sites, one here in Cheyenne and one in Evanston. And lastly, the third operator that's currently active has been approved for 1,289 terminals. Of those 1,289, they have 1,043 operational. So they're currently using 81% of their approved limits. And our fourth operator, our newest approved operator, they don't currently have any approved terminals. So they're not on this list. I just wanted to give you those numbers. And then I would also, maybe just a point of clarification for myself, under page 4, lines 8 through 13, it starts tying the terminals to 1,200 per flat track race or racetrack. So a little bit of background. Currently, parimutuel wagering is allowed for flat track racing, chuck wagon racing, roping, and rodeo events. Now, currently, the commission does not license roping or rodeo events because there's some caveats in the law that do not allow us to do that as far as background checks go. However, if that were to change and we began to license rodeo events, the one question that I have about this is it says, or other parimutuel event day. And I'm not exactly sure if that would mean that an operator could come and they could do a couple of days of rodeo in Casper and a couple of days in rodeo in Cody and a couple of days in Cheyenne. And then that allowed them 3 permitted grounds for a total of 3,600 terminals for running 6 rodeo days. Just maybe food for thought. I'm not sure if that's what that was intended to do, but I just wanted to bring that up.
Thank you, Director. Just once again, for the edification of the task force, why has the Gaming Commission authorized all these terminals that are not being used? I mean, what was it? I mean, I think I get the reason you're trying to do it for growth. However, without an ending point, like to those approved terminals that they have not used, what, are we doing anything different? Or maybe I just don't understand how we got here, like what the real meaning of those approved but not used terminals are. Could you help me out with that, Director?
Certainly, Chairman Kolb. So this is kind of 2 parts. So one of the big differences in the numbers is these newer builds that have been, that are very large touristic properties taking places on the border sites. The other big disconnect between these actually happened in 2020 when COVID hit. So a lot of these terminals were in place at these locations. And then when COVID hit and there was a 6-foot distancing thing, terminals were removed from service and spacers put in between terminals to allow for that 6-foot distance. And what the operators have said is that they have found that their customers actually like more elbow room, so they're not sitting on top of each other. So that is where that has grown more. I hope that answers your question.
Well, it does partly. And then the next question was, is those new buildings we're talking about, they're coming in with all those, supposed machines going in there. Has anybody evaluated the ability to put that many machines in those locations? I mean, has anyone done an analysis that says, you know, these will fit? Especially what you just told me with the spacing. The square footage of these buildings seem to be not adequate. I guess, so do you guys do an analysis of the building space? Do they sign an affidavit that says, yeah, we got the space to put these in and we intend to? I mean, how does that exactly work at your level?
Chairman Kolb, so with those large properties, we do look at render drawings, architectural drawings, spacings and everything else. So for example, the Cheyenne property, it's still in the early stages, or I'd call it their phase 1 stage. They plan on actually building onto that building that will house the additional terminals. So currently, right now, if you were to look at, the property just here outside of town, that one has been approved for 1,000 terminals. 1,000 terminals are not going to fit on the current gaming floor, but as they build out further, increase the footprint of that building, then those terminals will come into play, and they would fit in the new areas.
Yeah, thank you, Director. And eventually the world will end. I get that. But currently, we got a building footprint that cannot support that many machines, right? And I really don't care what they say they're going to do. They haven't done it. That's just, the future. So for you guys, why couldn't you just permit more machines, I guess is my point. Why couldn't you just permit more machines later on when they came in and asked, because they have the footprint that supports it? I mean, is there some restriction that you need to talk about? I'm not sure.
Chairman Kolb, I think to that point, I think, as the operators go, the operators would not want to, commit to making these multi-million-dollar investments in the properties without those approvals ahead of time. I mean, if an operator had to build out another $20 million footprint of a building without knowing that they were already approved to put those terminals in place, that probably wouldn't happen. So I think that's part of it when the commission is considering these. It is looking at the overall plans and the years of investment that they have to make for those. And maybe in a way, giving them some reassurance that when they make these investments, that the commission's not just going to come back and say, well, you've made all this investment in this property, but now we're not going to grant that.
Director, I understand the other side of the argument, but my question really comes down to is how long is that time period when you grant that extra machine permitting, right? That's really the question. I get people need assurances for expansion, right? I get that. But what I don't understand is it seems to be open-ended, that's all.
Chairman Kolb, I agree, and that's something that we have been working on, and that's something that I've addressed with the commission as well.
Thank you, Director. Co-Chair Line?
Thank you, Mr. Chairman. Director, my question is about retracting machines. Do those come voluntarily, or do those come from the commission saying your time has expired and you haven't built them into operation yet, and therefore you're only permitted for 60 machines when you had 80 once upon a time?
Chairman Kolb, Madam Chair, currently it's a voluntary relinquishment of those approved terminals. There has been discussion and there has been contemplation of reviewing some of these approvals and how long they've been out there, and the failure to add these terminals and retracting that. I think we're still working on that.
Follow-up?
Follow-up.
Thank you, Mr. Chairman. When in November they set their race dates, is that when they also do their permitting, or is the permitting done at a separate time?
Chairman Kolb, Madam Chair, it's done at the same time for both. The live event and the simulcasting permits will be done simultaneously.
Follow-up.
Thank you, Mr. Chairman. In November, can you tell me how many of these machines will be up for renewal at that time? Is it every machine, or is there an offset on different years for different companies?
Madam Chair, I'll have to look that up real quick. I believe this year we will be doing one. Let me correct that. So this November, we will be reviewing race dates for all of the operators, but full permit applications, we will be doing one full permit application. And then I believe next year we will have two. And then depending on how the one that we consider this year, depending on how they apply, if they apply for a 1 or a 3, it could be the next year or 3 years after this year.
Follow-up.
Thank you, Mr. Chairman. In the event that we switch to a 1,200 machines permitting process and we go to a live situation, what support does the commission need from the legislature to start to have a company draft these permitted machines into smaller locations if they want to house the large mega buildings, parlors, whatever you want to call them. I know they're not a casino, versus having them scattered throughout our communities.
Chairman Cole, Madam Chair, I'm not quite sure I understand the question. Can you give me that one more time?
I think I can.
Go ahead, Mr. Chairman.
Yeah, thank you, Co-Chair Line. I think the answer is that we have to draft statutory changes, that then they have rules that they draft from our statutes. It goes from us to them. So if we want to do that, we're going to have a statutory change to direct them, because they're an office of the governor's office, the Gaming Commission. So I think the answer is that we have to have a statutory change, Co-Chair. I think that's our best way of affecting that change. What do you, Director, what is your thoughts?
Senator Kolb, I would agree. Understanding it that way, yes, that a statutory change would then affect the commission to promulgate the necessary rules to help enforce that change, and then we would go from there to make sure that that's what happened.
Follow up?
Thank you, Mr. Chairman. Do you by chance have a breakdown of every company's locations and how many machines are permitted versus live for all of those locations? Say, there's one out here on Ridge Road for 307 Racing. Could you tell me how many machines are permitted versus live at that location?
Chairman Kolb, Madam Chair, I can, as a matter of fact. I'm looking at it. If my screen will go small again. Ooh. Madam Chair, so currently the Ridge Road property was approved for 125 terminals, and it's functioning at 125 terminals.
Thank you.
And I do have the breakdown of every location across the state, across operators. I will email that to you.
Thank you.
Thank you, Director. Further questions for the Director? Seeing none. Thank you, Director. Please stand by. I might need you back up here again. Further comments? Who would like to come up and make a further comment, public comment, I guess we'll just say at this point, if we don't have any agencies? Wyoming County Commissioner Association's not here? He stepped out. All right. I think. Go ahead, sir. Introduce yourself.
Good afternoon, Mr. Chairman. My name is Kyle Ridgway. I'm the Wyoming president of Wyoming Downs and 307 Horse Racing. We oppose this bill in short form. This bill has a lot of different complicated moving pieces in it that are mixed in a bill, which generally, in my opinion, is not ideal for legislation. We've worked for the better part of 3 years as an industry with the locals to develop the local control bill. And to the extent you have choices on sideboards, which we as an industry support, the local control bill seems like a much simpler and more effective way to get your arms around the industry. To start, let me just educate you on what a process is to permit a location. We'll talk about the Ridge Road location in Cheyenne, since I did all the work to permit that. So first, we start by entering an agreement with the landowner to acquire the real estate and the assets associated with that business. From there, we go to the county commissioners and present the proposed project to them. In this case, we presented the Laramie County Commissioners with a resolution that was custom, similar to the resolutions we've received in other counties, similar to the framework that currently exists in the local control bill. So a time limitation on the county's resolution, the ability for the county to revoke our permit, machine cap in the resolution, and a number of other factors. It's a matter of public record. We appeared in front of the Laramie County Commissioners at their public meeting, which has an agenda, there's information in the packet. We appeared, we obtained the resolution. Thereafter, we had to work through a zoning process. So the city of Cheyenne already has a zoning code. the city council has delegated its zoning authority to the Board of Adjustment. And as I understand it, the city council appoints members to serve on the Board of Adjustment. What we had to do for this Ridge Road property is file an application for a zone special use permit, because under City of Cheyenne Code, parimutuel wagering is considered a other use that requires a special use. So Ridge Road was a commercial business zoned property. There was a liquor license already associated with that property. Liquor falls in the existing use, but parimutuel wagering did not. So we went through that process with the Board of Adjustment, which required a public notice. We had the sign out in front of the building. We had to send the letters that we paid for to all the neighbors. We had to go through a public hearing. As a result of that public hearing, in order to obtain the zone change, the Board of Adjustment required us to close the access from Pershing Boulevard onto the property. We had to re-landscape the property. We had to sprinkle the property. We had to do a bunch of things to bring it up into compliance to obtain the zoning. Once we went through that whole process, which takes 90+ days, we then filed our application with the Gaming Commission. When we file with the Gaming Commission, we include the county approval. We also include the information about the zoning. The current Gaming Commission process is to turn around and send our application to the county and the city to give them specific notice that the application's in front of the Gaming Commission, for them to have an opportunity to come in and speak on the application. Cities and counties have appeared and spoke. Most recently, the city of Laramie showed up. City of Cheyenne has shown up to meetings, City of Sheridan has shown up to meetings and spoke about properties and applications that have been in front of the Gaming Commission. As a part of that Gaming Commission application, you put your machine count in, you put your security plan in, it's a packet this thick. And then the Gaming Commission goes through its statutory analysis related to, is this to the benefit of Wyoming? Are the machines oversaturating the market? Which they compare to the study that the legislature paid for a couple sessions ago. We provide a study, typically for our border site. We had a third-party independent study to support the idea that 700 machines at our border location would fit the market for northern Colorado. And that individual who did the study appeared in front of the Gaming Commission and was allowed to be asked questions. In other cities, Sheridan, the zoning goes through the city. Sheridan went through, we went through a zoning process in Sheridan for our properties there, very similar. The difference is you go to the city council because they haven't delegated it to a separate board. In Rawlins, we went through a special use permitting process where they required me personally to go knock on every door within 100 yards of the property, which I did, and obtained signed approval from neighbors. And then there are other communities like Casper, who I've talked to multiple times, who have not, for whatever reason, placed parimutuel wagering in the zoning code. Now, to address this misnomer that cities haven't had an opportunity to zone this, let's go back to first principles about what this statute calls historic horse racing activity. It's called simulcasting or off-track betting. Off-track betting in Wyoming has existed for a lot longer than the 2013 legislation. Off-track betting in Wyoming existed in the 70s. If you're familiar with Evansville, where the old All Creatures property used to be, there's a kind of bombed out bar with a big satellite dish on it. It still says Wyoming OTB on the side of it. That's been there since the 80s. It was an off-track betting facility for simulcasting. So cities like Cheyenne had this in their zone code well before 2013 because they had off-track betting activity in their community. Same with Sheridan, same with Rawlins. So because HHR falls under parimutuel wagering, which is something that's been legal in Wyoming since the 60s, this is not a new thing for them to have had in the zoning code, because an off-track betting shop back in the day, sort of had the same reputation that these do. I think these are a lot cleaner than what these simulcasting facilities used to be, like at the old Shiloh Inn in Casper. So I think this bill is seeking a problem where the solutions already exist. Like, the cities have had decades to deal with the zoning, and they have zoning tools to deal with this. And there are a number of other things in this bill, which a lot of you talked about. I mean, The amortization concept is super problematic for us as an operator. We have this Pershing facility here in Cheyenne that we spent $20 million on to take a building that was completely vacant and build a full-service entertainment complex, including a liquor store, a bar, a brand-new state-of-the-art bowling alley, some amenities that are some of the first in the Western United States, an arcade, a family entertainment center, and a OTB section. And for that property, we went through a zoning process, similar to Ridge Road. Because we were putting a liquor license there that hadn't been there before, we had to spend $2 million on parking lot upgrades. We had to put sprinkler systems in to the landscaping that we had to add in the middle of the parking lot, which was just a wide open parking lot. We had to change accesses, sprinkle the facility, the whole deal. So I think that this process that we already have works. And what this bill kind of does is it's almost like it's intended to punish the operators for something that the local governments have failed to do, that they've had decades to put in place. And, you know, the industry operates within the guidelines that it's had, within the contours of the statutes that it's had. This idea about machines not being used, you heard from Executive Director Laramendi, at least for our organization, for 307, he gave the numbers. We are permitted for 1289. We have 1,043 in. The only ones that aren't in is we have a property under construction that's not completed. When it's completed, 125 machines go in that Green River property, and we're about there. For Wyoming Downs, you heard it was at 50%, but we have 700 going in a border facility that's going to take 18 months to 2 years to construct because it's a multiple $10 million plus project. That's significant. That property will fit all 700 machines at the beginning. It's not a phased plan. That's what's being constructed. I can't speak on the other one, but you know, the idea that the unused machines, I think that's kind of a misnomer. It seems to me that some of the issue is people just feel like there's too many of these facilities. And we did submit a bill to you all around population caps that I know is not part of the agenda. That was something that the Joint Appropriations considered 2 summers ago that would really solve the problem I think Representative Lean was talking about with there's just a lot of these salted around, and how do we get these to consolidate? You can do that through this population caps bill. There's pros and cons to it, but it's another alternative to consider. We as an industry were asked to bring things.
Sir, excuse me, we have a time constraint, so just if you would, stick to the bill we're talking about. And we won't venture off into another bill quite yet because we could spend a lot of time doing that. So if we just talk about this bill in front of us.
No problem.
Appreciate it.
Apologies, Mr. Chairman.
No issue.
I do think the point that Director Laramendi brought up about pari-mutuel event on page 4, line 12 is significant. I don't think we want to end up having people run rodeos and then get these machines. I would be very careful about that. Rodeo is a much lower overhead thing than live flat track horse racing. So a lot of this we already have, and I think that a lot of the things in this bill just sort of confuse issues, and we'd encourage you to look toward the local control bill that I think is a simpler process for locals to either say yay or nay or revoke, and not get into some of the complexities of land development around zoning that I think create unintended consequences. Happy to stand for any questions.
Thank you for your testimony. Task force questions? Seeing none. Thank you, sir, for your
Thank you.
testimony. Is Mr. I guess, okay, all right, thank you. Further testimony?
Thank you, Mr. Chairman. My name is Affie Ellis, and I'm here representing Cowboy Racing. With me, I have
My name is William Edwards, Cowboy Racing.
Thank you, Mr. Chairman. I want to thank the bringers of this bill for providing an alternative approach to addressing and clarifying the roles of local government and regulating simulcasting out activity. At the outset, Cowboy Racing appreciates that this bill treats all the operators similarly and doesn't single out new operators who are trying to enter and compete in this market. If you'll indulge me for a bit, I want to talk about a case that really speaks to this point, and it's the Wyoming Downs versus Sweetwater County case, which was decided in Wyoming's 8th Judicial District in 2015. Then Judge Couts issued an opinion letter, which is worth highlighting. In that case, Wyoming Downs, who operated and continues to operate a horse racing facility in Evanston, had applied to operate a simulcasting facility in Rock Springs. A competing business, Wyoming Horse Racing, operated, and they continue to operate a live horse racing track at a leased facility in Sweetwater County. Wyoming Downs, per the statute, sought Sweetwater County's approval to operate a simulcasting. However, and I'm reading language from the case, at the meeting to consider the request for the approval, the Sweetwater County Commissioners made several statements expressing their concern about the impact that Wyoming Downs' proposed facility would have on Wyoming Horse Racing's business. So of note, the case stated, with the managing member of the Wyoming Downs urged at the hearing that they had a right to compete, one of the commissioners responded that it was the board who had the authority to determine who could operate a horse racing business. The board ultimately denied Wyoming Downs' requested approval. So Wyoming Downs sued. They argued that their denial was arbitrary and capricious, a violation of equal protection laws, and that the Sweetwater County Commissioners exceeded their statutory authority. The court agreed with Wyoming Downs. Beginning on page 8 of that opinion decision letter, the court cited 2 cases from another state and stated that it had reviewed a similar issue concerning the legitimacy of a municipality's use of zoning authority to engage in economic protectionism. The court went on to explain that local government should not be engaged in anti-competitive acts, stating it must be clearly stated in zoning laws or ordinances that they cannot be the basis of limiting competition. They also cited a case called Sun Oil Company versus Board of Zoning Appeals, which was an Ohio case, stating that the law is well established that a prohibitory ordinance must be general and uniform in its operation, and if it tends to create a monopoly, it cannot be sustained. So Judge Couts found that the county's decision was arbitrary and capricious, that they had exceeded their statutory authority, and that their decision unconstitutionally violated Wyoming's Equal Protection Clause. This is an important case, not just because of its conclusion, but because it also highlights the references to local authorities' existing powers through zoning and other approvals. If a municipality or county zones for simulcasting, either by zoning in or zoning out, applicants like Cowboy Racing would know where we can propose a facility and where we cannot. That provides business certainty. So we support this legislation so long as those zoning ordinances are developed to be general and uniform in operation and not designed to create a monopoly, or in our case in Wyoming, a duopoly. We've heard and we'll likely hear that land use or zoning planning isn't an effective tool because there are some places in Wyoming that don't have land use plans or zoning ordinances. So out of curiosity, I looked at a list of municipalities in Wyoming, and I handed out to you a list of all the municipalities in the state of Wyoming that I got from the Wyoming Association of Municipalities website. On the sheet of paper, you'll see highlighted in red that there are several municipalities located in the 7 counties that do not have any parimutuel activity approved. So those in red are in Lincoln, Sublette, Park, Bighorn, Washakie, Crook, and Niobrara County. Again, none of those counties have approved parimutuel activity. Highlighted in yellow, though, are the current municipalities that currently have at least one or more gaming facility. There are 15: Cheyenne, Casper, Gillette, Laramie, Rollins, Rock Springs, Sheridan, Evanston, Green River, Rollins, or Douglas, Buffalo, Mills, Evansville, and Thermopolis. You'll note that of these 15 municipalities, they are all located in the largest municipalities in the state, and all of them have some form of zoning. So from that list, I added a check mark to indicate whether that municipality has some form of zoning with a check, and then you'll see an X where municipalities have no zoning at all. You'll see that it tends to be small communities with fewer than 1,000 residents that have no zoning, places like Hanna, Shoshone, and Lingle. However, even some of the smallest communities like LaGrange, population 372, have a zoning requirement which prohibits, for example, no sexually oriented business shall operate within 1,000 feet of any school, child care facility, or other building that regularly is used for a place of worship. So that's zoning in LaGrange at 372. The same could be done for gaming. In short, zoning, and I want to thank Chairwoman Lean for understanding this, zoning tells us where we can operate facilities, when we can operate them, and they can control how big these facilities are. Zoning, however, cannot be used as a tool to decide who can operate, as Wyoming Downs versus Sweetwater County instructs us, because entrusting local governments to decide who can and can't do business runs the risk of local governments engaging in economic protectionism or monopoly or duopoly creation, which is an inappropriate use of government power. So for all of these reasons, we appreciate that this bill draft would encourage counties and municipalities to use their existing tools to control growth of gaming and clarifies their authority. I think you just heard in prior testimony the extensive lengths that local governments have required for other projects and other operators. These are not things that come together quickly. There are a lot of requirements, and local governments have a lot of tools. However, we have further comments on this bill. On page 4, lines 1 through 6, as you've heard, this language would prevent an operator from seeking approval for new gaming facilities if they haven't built out their facilities that aren't currently in use. I don't think anyone's, necessarily that language alone stops them from eventually applying for more machines. It just requires them to fully utilize them before they're allowed to seek more. However, this is something that we can't gloss over. The following paragraph on lines 8 through 10 would then limit each permit holder to operate no more than 1,200 machines per permitted track. As you've heard from the Gaming Commission and from us in prior testimony, Wyoming Downs currently has been approved for 1,800 machines and has 1,200 on their floor. And I handed out a chart. This was taken from the June meeting, and Mr. Laramendi, I believe, provided you with more current numbers. So take that with a grain of salt. These numbers are already inaccurate. But if you look at some of those facilities, I think the Beacon Club was used as an example when we've talked about these issues. There are currently 66 machines in that facility, but it's been approved for 96. At some point, it might be helpful for the committee to ask for a true-up on those numbers. But in looking at those numbers, it is important to note that Cowboy Racing has applied for fewer than 300 machines, and they're all located in Laramie County. So I highlight these numbers because with the exception of Cowboy Racing, each operator has exceeded the 1,200 cap that is proposed in the bill draft. Thus, I'm guessing that maybe the language on lines 1 through 6 might be unnecessary since they've already hitting those numbers. Accordingly, we'd recommend striking maybe lines 1 through 6 on page 4, but only because of the additional language that's below it. The committee, in looking at the caps, may wish to consider language that clarifies that the caps would still allow for operators to lease machines to one another. For example, the state of Arizona has negotiated compacts with various Indian tribes to operate Class 3 slot machines. Certain tribes are allocated a certain number of machines, and tribes located in rural areas are allowed to lease these machines located to other tribes in metro areas like Phoenix, where there is a more lucrative market. There's a lot more of these to these compacts and agreements, of course, but we wanted to provide you with an example of how this works in other markets. So in Wyoming, if a cap were in place, a company like Cowboy Racing, they could build their track, and instead of constructing their own gaming facilities, Cowboy Racing could lease some or all of its 1,200 machines to existing operators. This would potentially consolidate the number of locations and allow the private sector to sort out the details of those lease agreements. Cowboy Racing also could, for example, negotiate with Wyoming Horse Racing to lease 700 machines for its Swan Ranch facility that would allow them to build out their project. Or it could lease machines to Wyoming Downs for their proposed facility. So I highlight these, Mr. Chairman, because instead of our competitors fighting Cowboy Racing's entrance into the market, they might actually embrace our efforts to build a track because it would mean more opportunity to lease machines from us. Therefore, we would suggest inserting language to clarify the ability to lease machines in that section of the bill on page 4, starting on line 14. However, we have an additional suggestion to distinguish between privately owned tracks versus publicly leased tracks in terms of how many gaming terminals each operator may utilize. We would suggest as follows. The classification could be defined as a Class 1 track is a privately owned track, which is 7/8 of a mile or larger and conforms with common industry safety regulations developed by the Gaming Commission, on which live racing is conducted for a minimum number of days. And these Class 1 racetracks would be allowed to operate 1,500 commercial electronics devices statewide. By contrast, a Class 2 racetrack would be something less than that, a publicly owned track on which live race days are conducted for a minimum number of days, or a privately owned track which is less than 7/8 of a mile. These Class 2 track holders would have fewer games, 1,000 perhaps commercial electronic devices statewide. So the Wyoming Gaming Commission, could then be required to hold that allow these holders of the Class 1 or Class 2 track permits to enter in lease agreements with one another to operate the HHR devices dependent on commission approval. We'd also recommend if you go down this path, you should consider that the Gaming Commission may be not allowed to permit no more than 4 or 5 tracks, Class 1 and Class 2 tracks combined, statewide, and to give a preference to applicants seeking a Class 1 permit. The Gaming Commission could then also add further for clarification, saying that they want these tracks spread apart, not within 100 miles of one another, but also give more preference to those seeking a Class 1 permit. So I've provided you a conceptual amendment to that effect. You'll note that we suggested limiting the number of tracks so as not to create an incentive for an operator to lease a public facility for a nominal amount of money, run the minimum number of race days, and allow that operator to build a gaming empire. The focus should be on encouraging operators to invest in live horse racing by investing in permanent tracks that are privately owned and contributing to state property taxes. In closing, I think it's worth noting that it is unusual for an operator to be okay with capping the number of machines. We acknowledge that ideally, Wyoming wouldn't have the need for caps at all, and that the growth of gaming Wyoming has experienced in the past decade would have been more measured. But it hasn't been. We've heard from many elected officials, both at the state and local level, that there's too much gaming. We're trying to work with those leaders who share this sentiment. But simply cutting off new entrants into the market isn't the solution for controlling the growth of gaming. Fencing out new operators and new competitors would only allow existing operators to continue to grow their operations while preventing competition, which is the wrong approach. If local governments have had enough of these gaming facilities popping up in their communities, the only fair way to control the number of machines is for the state to intervene and manage the growth in a way that is fair to each operator. When cowboy racing appeared before the Laramie County Commission in early January of 2025, we were asked, what's the sustainability? When is this going to stop? Well, if you have 5 licensed tracks and each track operator can apply for 1,200 devices, the math is simple. 5 times 1,200 is 6,000. That's it. That would be the maximum number of machines in the state of Wyoming. If you adopted the classification system, under the current scenario, you have 2 track operators that are privately owned with 1,500 each, and 2 that lease their facilities for 1,000 machines each. That would be 5,000 machines total statewide. If all of those operators all developed privately owned tracks and you had 5 permitted tracks, again, doing the math, the max would be 7,500 machines. Those are certain numbers. And with those types of limits, operators would have to be more strategic in where they place machines. And it's highly unlikely that you will see these machines cropping up in small towns that don't have an adequate market or the regulatory controls. Again, looking at this list, if you were an operator, where would you put your machines? I think it would be highly unlikely to put them in any of the towns that fall in the furthest left category, places like Casey, Midwest, or Pavilion. I just don't see the markets being there. So with that, Mr. Chairman, without some kind of cap or other equitable control, I don't know how to answer the question about when the stopping point is. But we are trying to work with some solutions and some alternatives, and we think that we just appreciate, again, the bringers of this bill for providing an important starting point for an alternative discussion. Mr. Edwards, I don't know if you had any further comments. I'm happy to answer questions from the committee, though, at this point.
Thank you. I'll be real brief.
Mr. Edwards?
Yes,
Please continue.
Mr. Chair, Madam Co-Chair. I'll be really brief. I just had 2 comments about earlier testimony, and that was, the first is about this unused machine provision. What I think it's trying to accomplish is to prevent people from kind of banking a large number of machines and then not building them out. And that would be for one location. What I would strongly recommend, if this committee moves forward with that provision, is that you limit that to per jurisdiction. In other words, if one operator wanted to open up a location in Laramie versus Sheridan, for example, they should be able to proceed with both of those locations simultaneously instead of having to build out one before they proceed to the other. So I would strongly recommend that you add the per jurisdiction in that term if that provision is to move forward. The other real quick is to talk about this notion of parimutuel rodeo. I think it is very interesting. It could be very positive for the state of Wyoming. However, I don't see the nexus between HHR machines, which is historic horse racing machines. The games are completely based on historic horse racing, and allowing a operator of rodeo to use historic horse racing machines. There's no nexus there. So while you should possibly allow parimutuel rodeo, I don't think operators of parimutuel rodeo should be allowed terminals. So With that, I'll stand for questions. Thank you.
Yeah, thank you for your testimony. Task Force questions? Representative Johnson?
Thank you, Mr. Chairman. I would just like to say that the reason we have, this is just a statement, the reason we have these off-track betting is to promote horse racing. So why in the world would we allow rodeo to have these machines? That is not going to help horse racing. We want to improve the stakes and the purses and the quality of horse racing in Wyoming. That's the basic idea of this whole law. And I think we're getting lost in the weeds in this. And I think we need to get back to, we just want these machines to improve horse racing in Wyoming, and I'll just let it stand at that. Thank you, Mr. Chairman.
Yeah, thank you, Representative Johnson. Co-Chair Line.
Thank you, Mr. Chairman. I just wanted to say thank you for this chart that has all the zoning regulations listed on it. This has been incredibly helpful.
Mr. Chairman, if I may, so when I put the check on there, I want to be clear that the check doesn't mean that there's specific zoning for gaming, just that there's zoning. And a lot of it, the example that we use are shops that have, adult entertainment type things. And that's why I illustrated Lost Springs. And so I don't think the zoning needs to be so onerous, but some guidance would be helpful. But it does get back to this question that hasn't been teased out, is what is local control? We are very supportive of local control if you tell us where, how big, hours of operation, and that's uniformly applied, or makes sense, if you have a certain area of town that has different hours of operation than a different, as long as it's fair. I think our biggest concern is the who, and that's our biggest concern with the next bill that we'll be discussing, is that does say, yeah, you get it, but you don't. We like Will, but we don't like you, Affy, you don't get your permit. That's the fairness part of it that we don't like. Thank you, Madam Chair.
Representative Ellis, or Representative, former Senator Ellis, Council. How many of these different localities here that we see by municipalities, by population, I don't really see the counties here, but have gaming regulations? How many of these are there that have gaming regulations?
Mr. Chairman, as I said, none of them have, that I'm aware of, have specific zone, they haven't zoned yet for gaming. I think that there are some of the larger municipalities who are starting to look at that issue. We're aware that the city of Laramie, I've been visiting with some of their elected officials, they don't want them in the historic district. So I think one idea out there is what happens if Laramie says, we're going to zone out, we don't want you in our historic district. So then they could decide, well, but we're comfortable with maybe if you wanted to, create a district that's by the interstate or whatever. But then again, operators would know, and, Will and his team can look at the zoning map and the definitions and say, okay, these are options for us. And then it's up to all the operators to compete on who gets the best spot first and who can go, that's competition. But so to be very clear, none of them have, but I do think that there are some municipalities who are looking at it, including the city of Cheyenne. The challenge with Cheyenne, as we know, is it's very much been built out already, even though we've heard testimony that they could have zoned for this as early as the 70s. And so we are hoping that our existing municipalities will use the tools that they're given and the tools that they have. I do think this bill makes it very explicit that that's the expectation. I do think they have the power to do all of this already, but it's not as explicitly spelled out in the bill, or without the bill.
Senator Crago.
Thank you, Mr. Chairman. So this question could be for either one of you. Let's assume a city does exactly what you just said. Let's assume Laramie creates a very discrete zone for gaming. And let's say it's rather small. What prevents one of the operators who may or may not have a lot more funds available than the others from going in and buying every single piece of property within that district? How does that not eliminate competition? How does that not create a monopoly in that particular district?
Thank you for the question, Mr. Chairman. Senator Crago, if you go back and read that Sweetwater case, then it would be up to an operator that maybe was excluded from that very, very narrow zone that was created for gaming, for new gaming, to say, hey, we think that this was created to perpetuate the monopoly or duopoly, and then I think there would be a legal recourse that could be examined for that. So I think if the planning were looked at more broadly and more equitably, what does the city of Cheyenne look like? Here are some areas. You wouldn't run that risk. And that court opinion very succinctly says that there is a distinguishing line. If a zoning ordinance was enacted with the intent to create a monopoly or provide for economic protectionism, that can't stand.
follow up?
Thank you, Mr. Chairman. I'm not talking about a circumstance where the zoning authority has any intent. I'm just talking about the circumstance where one operator says, we're going to make sure we have no competition because it's worth it, right? Let's take the city of Cheyenne, right? Has a very large market, has a market coming in from the south. And one operator says, we're going to create a monopoly and we're going to do it because we have the money to do it. I think we run that risk. I mean, I think this bill creates that potential risk for you and for every other operator out there. I mean, all of them. And especially if you're one of the newer, smaller operators, I think you run a very large risk by relying on zoning to create a fair atmosphere. But that's just my comment on it. I'm concerned that that's where the bill will go.
Mr. Chair, Senator Grego, I think the distinction lies with government action versus private action. As far as the government is concerned, it's a zoning that should be equally applied, and the government actor in there is fair. If I understand you correctly, in your illustration that the private actor comes in and destroys the competition. I see how that could be problematic, but as far as the government and the government action is concerned, it's applied fairly.
Mr. Chairman?
Counselor?
Mr. Chairman, maybe stated another way, that's where we lost the competition on the private sector side. But that was still the government setting up a fair, I think a better example would be like Rollins or Laramie that says, we're going to, here's this strip of area right by the interstate, and that's where the only place we're going to want HHR. Then it's a race between the private sector, and that's where we compete. And that, as long as you guys set up, this is the zone, this is the fair, then it's up to us to compete. And if we lose on that competitive basis, that's our problem, not yours. As long as that area is fair. And that's competition, right?
That'll be a monopoly.
Mr. Chair, if I may, Senator,
Hey, said a
if
second.
I was in that situation.
Hold on a second.
Oh, I apologize.
You can go now, okay? You can't just
Yes,
talk
sir.
over people, all right? Let's just keep order. So you can respond to the position or the question from Senator Grego.
My apologies. I think I'll withdraw my comment.
Co-chair line.
Thank you, Mr. Chairman. Mr. Edwards, would you agree that this would be no different than an industrial park that is set up, and the first person to occupy that industrial park would be the person that is then going to be able to run their business successfully? This would be just for HHR machines instead of industrial count.
Mr. Chair, yeah, I would agree with that.
All right, Representative Johnson?
Thank you, Mr. Chair. I have a question. If we limit these machines to 1,200 or whatever, 1,500, however we do that, that would limit the possibility of buying out a whole block of the city that is zoned for that. Then they would have to build that out. I don't think that'd be profitable. So I think we have to include the amount of machines per track in this proposition. So I just want to have some clarification on that. Thank you.
All right, thank you.
Mr. Chairman, I would agree, and I think that's why this bill has some powerful concepts in it. I mean, the zoning alone, I get it. You start looking at this municipality list, and then is it a call for every municipality on here to start having to proactively zone? With the caps, there is a finite number, and as an operator, we would have to look at the most strategic market of where to place our machines. And I think you would see, efforts maybe to consolidate more. It can't be understated that part of Cowboy Racing's, proposal in building their track, which I want to appreciate, or tell the legislators who were able to attend yesterday, thank you for coming. You saw how massively large it is. It's a huge undertaking, moving tons and tons of dirt. In addition to that, to couple with our track, Mr. Edwards and his group will have to come up with money to renovate new spaces, to house machines and all those servers and all of those kind of things, additional costs. But with a cap, if there's an incentive for the other operators to seek out our machines, we could very easily say, you know what, we don't want to build out these. We don't want to pop up more little gaming facilities within the city limits of Cheyenne. two of our competitors both want these machines. Let's talk to them and negotiate an agreement. So I do think those caps really help control that growth. And so the need for zoning and the need for all of this planning might be diminished to some degree because there'll only be so much more growth left. So these two concepts really do work hand in hand. And so again, I don't, if you have caps, I just don't think you're going to see machines popping up in little towns where maybe they shouldn't be.
Okay. Representative Webb, you win.
Thank you, Mr. Chairman. Okay, I'm a little confused because if I'm hearing things correctly, you're saying that zoning can take place. And I'm hearing from other sources that zoning can't take place. And I'm wondering why there's this conflict. Somebody's got to clear it up for me. I'm not seeing it.
Thank you, Representative Webb. We can probably talk about that further, about the taking issue or the methodology that was used to try to talk about how we compensate for people, for the changing of their zone rights. Fact is, that exists. Fact is, Wyoming doesn't do it. There's a reason why we don't do it. Now we're talking about trying to get a hold of the gaming world and trying to do it maybe through that mechanism. So to be clear, the people that have testified said that it is an issue, right? So there's no conflict there. It's going to be an issue. The question is, how do we solve it? If we want to solve it in that manner, and then the ramifications of solving it in that manner. That's really kind of what it is. You're right. It's a big lift for coming into this conversation about zoning and just how that works. Just to summarize it, but Representative Johnson?
Thank you, Mr. Chairman. I'd just like to interject that I think we haven't seen this growth in off-track betting machines come in the way it has. And I think that Cheyenne will admit that they were behind the ball and that their zoning regulations weren't up to par. They weren't ready for this. But from now on, it should work out. It's my understanding. Thank you.
Yes. Thank you, Representative.
Mr. Chair, may I?
Yes.
I think part of the issue is a confusion between a regulatory taking and a physical taking. The United States Constitution has the takings clause that government can't take property without just compensation. There's regulatory takings and then there's physical takings. And it has been renownedly supported that zoning laws are regulatory taking, and they have been renownedly supported and upheld throughout all across the country that it is not an unconstitutional regulatory taking. And so I think that is the distinction there.
Senator Crago?
Thank you, Mr. Chairman. So, Mr. Edwards, are we talking about existing uses? When you make that statement on regulatory takings, are we talking about existing uses or future uses?
Mr. Chairman, I was talking about future uses.
Follow up, Mr. Chairman?
Follow up.
And so just to be clear, there is a taking involved when you try to regulate existing uses, which is why we have grandfather clauses in that conversation that came up earlier, correct?
Under, Mr. Chairman, Senator, under that scenario, yes, there is problematic if you wanted to take away existing operating businesses. What I think we're proposing is businesses from moving forward that are opening up from this point on. But as was testified earlier, there's amortization and then there's grandfathering.
Mr. Chairman, follow up. Thank you, Mr. Chairman. So I just want to make it clear for everybody that's listening and for the committee, you're talking about this bill applying to new uses, new facilities, not facilities that are already in existence that, for example, are sitting in Cheyenne today. We're talking about new facilities that could possibly be placed in Cheyenne or any other municipality that has zoning in the state of Wyoming.
Mr. Chairman, Senator, that is, yes, correct.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Craig. And therein lies the rub, right? We're trying to deal with the two things at once, future growth and what are we going to do in current situation, which is always the problem with zoning, because it is what it is right now. And these other municipalities clearly have the authority to have zoning and have not done it. And that's fine, that's their local choice. But that's the conundrum here. That's always been the problem. It's simple to start at ground zero. It's a little tougher to deal with existing situations. So that's what we're trying to wrestle with these bills, just to be clear. And Co-Chair Line?
Thank you, Mr. Chairman. Along the lines of questioning of Senator Crago, I would say, would you agree that there's a change of use permit, vested permits, grandfather clauses, which we could all use to help navigate the current and old and future use moving forward with zoning?
Mr. Chairman, yeah, I think there's a lot of tools available. I think what this bill does with the language on amortization, and it makes that carve out in Title 18 that you see in the bill. I hate picking on my city, but say it's Cheyenne, and you have 2 of 307, the derby clubs are located right across the street from schools, and say the city of Cheyenne's like, we never should have allowed that. Maybe this bill would be a tool for them to work with those operators and say, we need to figure this out, future, how we amortize. Or they could say, we're just going to grandfather you in. We know you made this huge investment. You did, create this bowling alley we really like. We're going to grandfather you in, but going forward, we want to, prohibit certain facilities from being located within a distance from a school. So I think this bill gives that local. That's another tool for local government to control it. I think this could say you could do that, or you could do that. I think, and Mr. Chairman, if I just might add, and I know we're supposed to stay on this bill, but it's important to think about this public comment component. When you do a zoning change, or if the city of Cheyenne were to say, we don't want these things located near churches or schools, there's going to be a public meeting for that. When they have that discussion, that'll be the kind of lay of the land of the conversation. Do we think it's appropriate to have these near churches or schools, XYZ, whatever? The problem, and we prefer that. I think people are going to come from the community, weigh in, their elected leaders are going to hear what their constituents have to say, and they'll make a decision based on that. What we're fearful of, though, is it turns into popularity contests. House Bill 85, which is the next bill, revisited,
House Bill 85.
Turns into who can pack the room more for a particular applicant. Then it's specific to, that operator versus that operator versus that operator. And so then it's more targeted at the operator versus kind of the holistic rules of the game. And so that's why I think we like this bill, is because it's focused on the rules, not just the particular players.
I have a question, Council. If we've heard testimony that we're already at saturation, darn near saturation with these machines, okay? Then you're saying, okay, we're going to grandfather all the folks in, which we really have to do if we change these rules. What headroom is there for you to make any changes? In other words, if we're already at saturation, and then we're not addressing, because we can't really, without being a taking and addressing that issue, altogether, what are we talking about? You're talking about, it sounds like, on one hand, we're saying it's an open field, that we can kind of do anything we want and make this better. And the other hand, we talked about it being saturated. Now, if there's no gap between the saturation that we're now testified to, that we've got a lot of machines, and then the next advanced of other operators, how are we going to get those other operators going if we're already near saturation? That's my question. If we've already at 90% of the market, there's 10% left, and the controls you want to put on don't apply to those 90%, which is my scenario I'm building up here. What do we do about that? I mean, how do we address the issue of the current operators when they in fact encompass more than, I'll just throw a number out, 90% of the market? How do we do that? How do we affect the change? That's the question I have, Council.
Thank you, Mr. Chairman. I think this conversation with saturation gets a little off, in my view, a little off topic, because I think saturation is an important component for legislators and government officials to look at, decision makers. But at the end of the day, and Will can speak to this better, I think saturation, or just right before it or right after it, is where you're going to start seeing competition. And if you go look at some of these facilities across Wyoming, Will and his team have, they should be afforded the right to do it better. And if they do it better, then they're going to win customers. And if they don't do it better, then they don't. And so that saturation question, I think we're just trying to set a level playing field, not just saying, you were here first, so you win. Still allow for competition, but have some sideboards. Again, the cap idea comes into play in that regard. So, back to the bill, if you look at the saturation, how many games are you comfortable having in the state of Wyoming? I mean, 1,200 is kind of the number we picked for today. Could be more, could be less based on your study of those saturation numbers. But 1,200 seems to be about what, each operator kind of has. At the end of the day, if some of these operators want more machines, to do that, they would have to open a new track and have that permitted. So it's a bit of a dynamic model that other states use in different contexts. But I think that was our thinking in looking at this bill and supporting it. But Will, Mr. Chairman, if Will has more comments, I don't know, but.
Any more comments? We're about running out of time too. We've got other folks, I think, that want to comment on this. So appreciate your testimony. I guess, Task Force, you have any questions? No, not seeing none. Thank you for your testimony. I guess, Jeremiah, you were out of the room last time. Do you wish to make any comment about this proposed legislation?
Sorry about that, Mr. Chairman. At the time, the governor's office was calling, asking where my team was
The
to
governor's
attend
more
a
important
meeting.
than us, apparently. I guess we know the truth anyway, but
do
that's the way it goes.
You guys are incredibly important to me. Mr. Chairman, members of the committee, again, Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. I want to just start by saying that this conversation's been cast a little bit as a us versus them. And to be clear, my members have approved permits for all of these operators that are in the room with us today, and I'm with my members in support of them. Mr. Chairman, at this point, we don't have a position on the bill, but I suspect once I take this before them, they will be fairly strongly in opposition to it. I do agree with others that counties likely have the authority already under our planning and zoning statutes, 18.5, 201 through 208 already to do what has been discussed here. What this bill does is really kind of two things. First off, it takes counties out of that permitting or licensing process. And two, it forces counties to use zoning as the mechanism by which they might participate in this regulatory process. And I'll get to some numbers around what that looks like in the state, but I'll just use one quick example. Teton County. In the 1960s, as I understand it, the voters approved the ability for historic horse racing to take place. But since that time, the county has not authorized it for a variety of reasons, primarily more recently because of concerns that they wouldn't be able to impose the appropriate restrictions that they might want to put in place for that activity in their jurisdiction. What this legislation would do is say, we want to ignore the county commissioners that have made that decision and are going to force this activity upon your community. It's going to happen somewhere in your jurisdiction. Sure, could the county go about revising its zoning regulations? Yeah, maybe to a degree, but wouldn't be able to perhaps exclude it entirely from the county. So you're going to be forcing Teton County to accept something that they have made a decision that they don't want at this point in time. So let me get to a few numbers that I mentioned. And I agree, I've not found a single county that has gaming-specific county regulations, zoning regulations. But what I'll share with you is that there are 11 counties with some form of zoning throughout the entirety of their county. There are 4 that have some partial, and there are 8 that have no zoning regulations in place. For those of you that are members of the committee, Sweetwater, Natrona, Laramie, and Uinta fall into that entire county portion. Johnson County is in the no, and Campbell County happens to be in the partial category. Now, to a little bit about the issues that this legislation presents against what the current status quo is, we're really talking about two things. We're talking about zoning, and we're talking about licensing or permitting. Those are different things. Again, if we look at the counties without zoning authority, or with zoning authority, they could certainly use that as a tool, but not all have chosen to do that, and for good reasons. That was a decision of their community, that they didn't want to regulate the activities and the development of land. And I don't see that changing, other than this bill sort of suggests that if they want to have any say in gaming, they ought to be imposed upon them, that they would have some sort of zoning, which would create quite a stir amongst my members, and perhaps a stir amongst the public. In contrast, licensing allows for counties to participate as part of the regulatory process, and that applies across the entirety of the county. So licensing in that instance is preferable for us in relationship to this particular activity. Applicability. If you read the zoning statutes under Title 18, counties have the power to zone in the unincorporated portion of the county. They have no authority to zone within the municipality. So to the extent a county commissioner is concerned because one of their county residents that lives inside of a municipality comes to them and says, "Can you help?" we really wouldn't be able to do that. Now, if we have permitting authority, then yes, we would have the opportunity to participate in that conversation to help as part of the regulatory process. Next, revocation, a little bit of the difference there. Zoning approvals, generally once they're granted, are granted. You have no ability to revoke that. Whereas a license, on the other hand, or a permit, could be revoked if there's a violation of your permit. And that helps to ensure that there's some sort of ongoing accountability in the system. That's why licensing is preferable to us. You've talked a bit about grandfathering. Grandfathering would happen under zoning. We would not have powers unless we wanted to use perhaps the amortization approach that is put in this bill, or attempt to pursue a taking, which is going to cost the local government some money, which I don't think many, if any of them, are going to want to pursue that. Licenses, on the other hand, are renewable. That's why you see in other versions of the legislation before you that they have time permits. You heard from the director, 3 years is the general time permit around these things, which is helpful to have those ongoing checks. For those of you that have seen the saturation and the concerns about public welfare around this in your communities, zoning really doesn't allow for a community or a board of county commissioners to really address that post giving that grant. Whereas licensing would allow them to condition things both now and in the future. And then finally, enforcement tools. Usually enforcement tools around zoning are rather slow. You might be able to use the nuisance statutes that are there, try and seek some sort of injunction. Perhaps my members could go to the Gaming Commission and ask for some relief. But other than that, it's a rather slow tool, whereas a license can be revoked and fairly immediately, and you could seek to have that shut down immediately if there's an issue. So with all of these things in mind, we have a great concern about the approach that this legislation sort of sets up, and don't believe it's the right tool to affect what could be a good system moving forward. And with that, Mr. Chairman, I would happily stand for any questions.
Are any questions, Task Force, Co-Chair Line?
Thank you, Mr. Chairman. Thank you, Mr. Riemann, for being here today. The voters of Teton County, did they vote to approve the parimutuel wagering in their county?
Mr. Chairman, yes, that is one county that is authorized, but there are no county approvals, so there is no gaming there currently.
Thank you. Follow up?
Follow up.
Much as the state permits mining, could you talk to me about how county commissioners keep mines out of the center of towns?
Mr. Chairman, Representative Lean, it's a nuanced answer, because if you go into Title 18, there are a few exceptions to the county's authority to regulate mining. If you take mining in terms of the gravel pit that your community has had to grapple with, that is something that they do have the ability to use a conditional use permit around. But if we talked about mining more broadly, say gold mining, coal mining, or other activities of that sort, there are specific exemptions in terms of our authority. We don't really have a whole lot of authority, and I don't have that right in front of me, but I could get you that specific exemption out of state statute.
Thank you. I just want to note that there's a lot of zoning that goes with mining, and so some of that zoning law helps to contribute why we don't have them in the middle of towns, or in my case, on the edge of a town. In addition to that, I heard you say that the welfare of the people are not being addressed. Is that because we don't currently have zoning laws? Because earlier I heard that zoning laws help with the health, safety, and welfare of people.
Yeah, Madam Chairwoman, that's certainly one component of it. What it doesn't help with is once you've granted the right, you've granted a right. It is, unlike a license, that's a privilege where you can revoke a privilege. Under zoning, you have granted a right to them, and it's much more difficult to go back in and have a conversation about what you would want to change in that particular circumstance.
Thank you, Mr. Chairman. Would you agree that it's the Wyoming Gaming Commission's job to permit or not permit an individual when it comes to licensing for parimutuel wagering?
Mr. Chairman, Madam Co-Chair, yes, they certainly have a regulatory role in this process. I don't dispute that. In fact, if you look at the other bill draft, we indicate that if that was the approach you selected, then the county could not regulate within their authorities. But there are certain things that a Board of County Commissioners might want to address that should be a local decision and should be made amongst those elected officials. Not to disparage the Gaming Commission or any of the staff there whatsoever. They think they're doing a tremendous job and are a great partner of ours. But they are appointed individuals that sit in those positions, whereas boards of county commissioners, city councils are elected officials and should be able to make some of those decisions back home.
Thank you, Jeremiah. Further questions? Representative Johnson?
Thank you, Mr. Chairman. Mr. Raymond, the 11 counties that do not have zoning ordinances, how do they control SOBs, or do they? Are they just allowed to proliferate anywhere they want? What do they do to control those, or do they? And I think that what I'm getting at is they would have the ability to do the same thing with off-track bettings. So please explain that to me, please.
Director?
Mr. Chairman, Representative Johnson, you're going to have to tell me what an SOB is, other than what I
Mr. Chairman,
Representative Johnson.
sexually oriented business.
Gotcha. Mr. Chairman, and to be clear, there are 8 counties without zoning regulations, and in those particular jurisdictions in the unincorporated area of the county, they don't have any ability to dictate where those would be located.
Thank you, Director. Further questions? Seeing none, thank you for your testimony. Sir, could you introduce yourself?
Good afternoon, Mr. Chairman and members of the committee. I'm Dr. Mark Rinne. I am a board member for the Wyoming Association of Municipalities. I'm also the council president for the city of Cheyenne. With me is Justin Schilling, who is our director of member relations for the Wyoming Association of Municipalities. So I want to start off, if I can. There's been a lot of discussion up here on zoning, and it's been stated that municipalities already have all the control they need through zoning. But, Mr. Chairman, members of the committee, that's only partially accurate. In Cheyenne, we have only one area that's zoned for where it's a use by right for an off-track betting facility or historic horse racing. We have 7 venues in the city, and only one of those is in the appropriate zone. The other 6 have all gone through our variance process and received variances to locate in a different zone. And Mr. Chairman, a while ago, you actually made a reference to our Board of Adjustments. That was created several years ago. Cheyenne was under the perception or decided that the body that one appeals an ordinance to should not be the body that wrote the ordinance. So we created a Board of Adjustments to hear, things like encroachments into setbacks and the like. And that's really what it's been used for over the years. However, in the past few years, it's been used for historic horse racing venues to locate in a different zone. That is, as you referred to earlier, is an appointed body. It's a volunteer board. And generally, public really doesn't even know when they meet or what they do. And so, at least in Cheyenne, we, as the one that's elected by the people, I don't always have control over zoning. I also, an important part which Director Riemann referred to is if they do get a variance, and let me back up, we actually have a list of criteria if a building if it's appropriate for a variance. And that's actually pretty general, and it's pretty easy to meet all those criteria. But again, you have to kind of make it uniform for everybody. You can't single out a certain business.
Mr. Chairman?
Oh, we have a question. Excuse me, sir. Senator McEwen.
I'd like to know who approves the variances. Is it elected officials or just an agency?
Mr. Chairman, through you to the senator,
Yes, sir.
it's our Board of Adjustments that approves those variances in Cheyenne.
To follow up with Senator McEwen's question. So let's just say, so you guys, as your town council, you don't have a final approval then for the Board of Adjustment, whatever they do goes? Is that how it works? I don't know how it works.
No,
I'm
sir,
asking.
that's correct.
So whatever they approve, it doesn't go through that's the difference between.
Does not come, yes, sir.
You don't see it, so okay,
does not come back to us.
Okay, thank you for that was the question, I think, that Senator McEwen was trying to.
Mr. Chairman and members of the committee, the other thing I wanted to add to, which Director Riemann made a point of, and I think is very important and does not in 168, is the fact, again, if a zone change or a variance is approved, that's permanent. And I think there are instances where I like it being a permitted situation where we get to review it, say, on the same schedule that the State Gaming Commission gets to review it. I mean, obviously, these organizations, I think, even though they start out local, can be very attractive. And I think they're being bought up, or there are rumors of them being bought up by large national level organizations. And if it turns out that one of them becomes, let me clarify, first of all, with the ones we deal with in Cheyenne, and I talked to our chief of police, we have excellent relationships with the current practitioners in Cheyenne. However, if one of them is bought up by a national level corporation in Las Vegas or Atlantic City, they don't necessarily care about Cheyenne. And if they turn out to be a bad actor and not a good corporate citizen, I would like the ability to be able to review their permit. We cannot do that we cannot control that through zoning. We don't get another shot at that through zoning. So in that regard, again, we do not like this bill.
Mr. Chairman?
Hold on a second, sir. Thank you for finally clarifying you don't like the bill. I was a little, I didn't know. Yes, Senator McEwen.
So who appoints that board? I
Mr.
guess I'm lost. We're saying the elected officials should control the decision, but then a board does, and you have no control over the board. So who picks the board?
Well, Senator McEwen, hold on a sec. Just, you answer the question, but we got to stick on this bill. I realize that's a whole nother topic about what the city of Cheyenne's doing here. But we're not talking about that right now, but if you want to, sir, you can answer the question for Senator McEwen.
Sure, Senator, and to Senator McEwen. The board is nominated by the mayor of Cheyenne and approved by the council, and that's really all that we have to do with them.
All right, thank you for that clarification.
So
back on the bill.
Thank you. Yeah, if I hadn't made it aware earlier, obviously WHAM is not in support of this bill. And I just want to say, you got the two organizations that represent the elected officials closest to the people between WHAM and the WCCA, and we think there's a better way to do this, and this bill is not it. And then that's kind of my prepared notes, Mr. Chairman. I do want to address a few things that were brought up. There's been a lot of discussion on takings, and if we change a zone for something, in all my experience, those people are grandfathered into place. In my 26 years on the Cheyenne City Council, we have not had a taking, and I can't foresee that we would have one. And it doesn't happen with zoning. As you said, if we rezone something, the existing business does get grandfathered into place. The issue of amortization, I think, will be a headache for all of us. When I built my office building, my accountant recommended I amortize it over like 25 years. I'm sure their investments are even larger. They may want to amortize it longer, but at 25 years, that could be 4 or 5 administrations and several planning directors, and I'm not sure how you're going to keep track of that, and I'm not sure how the state is going to keep track of that. And finally, it was stated that with the cap on the numbers, then on the numbers of machines, then the most lucrative areas will, or essentially the largest municipalities are going to get all of the machines. And it was actually stated that, they don't go into small communities where they don't belong. Well, as a board member of WHAM, we really believe in local control. And who's to say that if there's a small community that decides they want to be a mecca for historic horse racing, and that's how they're going to develop economically, that they shouldn't be able to do that. And again, with the cap, it was already stated that they don't belong in small towns and it's going to go to the larger communities. So those are my comments. Mr. Chairman, members of the committee, thank you for listening to me. If you have any questions, I'd be pleased to try and answer them.
All right, we have a question. Co-Chair Lyon.
Thank you, Mr. Chairman. For the purposes of time, I'm going to name it as a two-part question. Within the zoning boundaries, I know that there's currently annexation of properties for residential neighborhoods or things like data centers, and you just stated that there's not been any takings to your knowledge that the city of Cheyenne has had to pay for. So my question is if you denied a zoning variance request, how would that affect a project?
Mr. Chairman, to the co-chairwoman, If the variance request was denied, then they would have to go into the one area that was zoned for that specific use.
Follow. Thank you, Mr. Chairman. My next question is about the Board of Variance or let's see, the city.
Adjustments.
A Board of Adjustments. Board of Adjustments or variance boards, whichever city or counties call them. Is it proper to say that you could dissolve their authority and give that back to the city council at any time?
Mr. Chairman, to the co-chairwoman, ma'am, I do not have the answer to that. I would prefer to talk to our city attorney before I could answer that. And so I will see if I can get an answer out of him and
Well,
get that to you at some point.
once again, let's stay on topic with the bill. We're not, I mean, that's a valid question, but not for today, I don't think. So the other clarification, you've stated that everybody who's, say, the zoning has changed, you've grandfathered them, i.e. what they've been doing hasn't changed because they had rights to that zoning use before you changed the zoning in their locality. Is that correct?
I did state that, yes, sir.
Okay, I just want to make sure it wasn't like nothing has happened. Well, in a way, nothing did happen because you can't change their rights in that easily, in that manner, right?
Correct.
And so that's the point I just wanted to make is the rights are still ongoing. So that hasn't changed, which means in other scenarios that we don't effectively move the needle because we haven't changed what currently people are doing. That was what I was trying to get to. And that you just can't have a taking. And anyway, thank you for your testimony.
Thank you, Mr.
In regards to
Chairman.
this. And then we have Representative Webb. Go ahead, sir.
One quick one. You mentioned if a bad actor, so if we have an operator and then we get somebody from Las Vegas, I think you mentioned, if they come in, we don't know who we're dealing with. It's my understanding that those people, people from Las Vegas or wherever they're coming from, they still have to have a background check and they have to be approved by the Gaming Commission in order to be able to operate. Isn't that correct, or are you saying otherwise?
Mr. Chairman, to the representative, no, sir, I'm not saying otherwise. I'm just saying that, and to be honest, I'm not knowledgeable to all the machinations of the State Gaming Commission, but I assume that they vet people thoroughly. All I'm saying is that if it turns out that we get an owner that's not one of our local owners, that don't necessarily care about Cheyenne and are not the ideal corporate citizen, I want to be able to have the ability to evaluate that, and at least on a periodic basis. I do not get that ability with this bill and with doing it through zoning.
We're good? Okay. All right, thank you.
Thank you.
Sir, would you please state your name?
Thank you, Chairman Kolb, Justin Schilling, Deputy Director with the Wyoming Association of Municipalities. Just really quickly, I'll keep this very brief. Obviously, we work with our folks on public transparency, holding meetings in front of the public, letting public be part of the decision-making process. One thing that this contemplates, and I talked with Dr. Rennie about this at length and multiple occasions, is a lot of times when one of these facilities pops up and you have a certain amount of the public that's upset about that, the first place they go looking is city council. Because they don't understand that right now it's county commission that approves the facilities and not the city council. By moving this all the way to the Board of Adjustments and those meetings being attended as they may be and usually being way out ahead of when a facility might be stood up, it really removes that public comment component. One other thing that came to mind during the testimony too, to avoid some of these conflicts and some of this, discussion of taking and having to basically run the investment of these companies out to a certain level before you might want to move their facility. I would suggest that if the committee is going to entertain this bill, that the enactment date give us enough elbow room that we could educate our members to try to get some zoning stood up before. this became the decision-making mechanism or the approval mechanism. That way we didn't have a situation where we were trying to zone after facilities were moving in based on the zoning that we have currently, or in the communities that don't have any, they weren't able to get that stood up. And I would take any questions.
All right, thank you. Co-chair Line.
Thank you, Mr. Chairman. Thank you for coming today. My question is, do your city council participants through WHAM currently attend the hearings for permittings through the Wyoming Gaming Commission?
If they have a permit or if they have a facility under consideration, yes.
May I address that, Mr. Chairman?
Yes, sir, have something, comment?
Thank you, Mr. Chairman. To the co-chairwoman. In the past, we probably have not. This has not been that big of an issue with us, but I know as of, I think we had some discussion on this at our last meeting in the winter, and it was pointed out to our membership that those hearings are going on, and I think now we do inform our membership that when the State Gaming Commission is meeting so that they can at least watch remotely.
Thank you. Further questions? Seeing none, thank you for your testimony. Anyone else in the room? We're going to go online next. Do we have someone to bring in if we don't have anyone else in the room?
Mr. Chairman, we have Peter Lagori.
Yeah, we have one other person in the room. So you want to come up and state your name and your position on this?
My name is John Romero Martinez, and I'm just going to say that I support this effort. I think there's been a few things I could speak to, but I think you guys spoke to most of them. So I'm just going to say I support it. I don't know all the answers to all the complex scenarios that were mentioned, although I think we're moving the ball in the right direction, but I had a couple of red flags when I heard some of the testimony of the senators online. I was listening to the online portal. But the issue of whether or not a gaming group becomes a bad actor, as a citizen, I did work for one of the groups, and maybe the city, our city leadership has had good conversations with police department regarding, there was a comment to that effect, that everything's kosher. And there was another important point of information shared with the group regarding sexually oriented businesses or groups or whatever that is. Seems to be there's lack of congruency here, but I would say it looks like it's moving the ball in the right direction. I don't know that this bill is actually making permanent authority. I think it moves the ball in the right direction. I could be wrong. I'll let you guys, the purview be your group. Either way, at least we now have a conversation going that could make proper amendments should they be needed, and that's all I have.
All right, thank you for your testimony. Any questions? No, seeing none, thank you. I guess, oh, Eugene, come on up, Eugene. We're running out of time. Well,
Eugene Joyce with Wyoming Horse Racing LLC. The one part of the bill that I completely disagree with is capping the number of terminals. And the reason is it inhibits our growth to grow revenue for the cities and counties, ourselves, and purse money for the horsemen that run at our meet. It's trying to come to equity of outcome, I don't think is the role of government. Equal opportunity to compete. And I believe that every operator, every permittee in the state has an equal opportunity. We've been operating under these rules for the past dozen years, and it seems to work. The problem that is perceived is that there's too many locations. And we're happy to work with the legislature. We worked with the county commissioners on their bill for the previous couple of years. And we're happy to work with you to try to have some sideboards for our industry. But again, I would oppose any cap on the number of terminals. When a liquor license is issued to somebody, they don't limit the size of your liquor store. They don't limit the amount of liquor you can sell at that liquor store. And, I think that the market will tell us when it's too much. But locations, I think that's the issue. That's the complaints that the Gaming Commission is getting, not the number of terminals. And with that, Mr. Chairman, I'm happy to take any questions.
Thank you, Mr. Joyce. Co-Chair Line.
Thank you, Mr. Chairman. I know that you mentioned the growth of the purse money, and so I'm curious, we have a percentage in state statute that drives to the Breeders' Cup, but could you walk me through how you delegate how much money goes to your purses? Because that's not written.
Yes, Mr. Chairman, co-chairperson Lean. And I spoke to Chairman Kolb about this yesterday. And I told him we have a contract with our Horsemen's Group, and that dictates a percentage of the gross handle that goes towards purses. And our purse money last year was 1.3 million. This year it's 1.9 million, and it's projected to be 3.2 million next year. And that is per contract with the representative Horsemen's Group. And so over the years, not only the percentage has gone up, but also the amount of money that goes to purses. And, the growth of purses and the growth of the number of horses, it's kind of a lagging thing. If someone decides to have a Wyoming-bred horse, it's going to be 3 years before you breed the mare and get that horse to the racetrack. But we're seeing a growth in the number of horses at our track. Also, the quality of the horses. I have 2 thoroughbred races this Saturday where there's horses shipping in from Del Mar, California to compete at Sweetwater Downs. And last weekend, we had the richest race in Wyoming history, $250,000, and we had 3 of the top 5 quarter horse jockeys in the nation fly in to ride into that race. So there's a lot of different metrics that we measure the success of horse racing. I mean, dozens. I mean, from the number of farriers and vets we have in the barn area to the availability of hay. We've got a vet in Evanston that just invested $3 million in a state-of-the-art equine hospital that was sorely needed. Before he built that facility, you had to drive an hour and a half down to the Salt Lake Valley when you had a horse in critical condition to help it. So there's a lot of indices that say that we are on the uptick. We're a national success story. And I would tell you, when I started 15 years ago, I was the Lone Ranger. There was nobody behind me for 3 years. We got HHR, and I believe we delivered on every promise we made to the legislature to grow the breeding industry, the racing industry, the race states, and as I said, all the metrics are on an uptick right now.
Thank you, Mr. Joyce. Any further questions? Seeing none, thank you for your testimony. We're going to jump online. Karen, can you bring in the online folk?
Mr. Chairman, I currently have Mr. Liguori, and I'll be bringing in Nick Hughes to follow.
All right. Sir, please state your name and start your testimony.
Chairman Kolb and Chairman Lean, my name is Pete Liguori. I represent Wyoming Horse Racing. And I know that the day is getting late. And I only had a couple of key points I wanted to make more out of clarification than anything else. Wyoming Horse Racing obviously does not support this bill for a lot of the reasons you've heard other people say, but mainly because we view the relationship with the counties and the cities where we operate as a partnership. And we really cherish that relationship and spend a lot of time making sure that what we're planning to do and are doing are in alignment with the local communities. So we think the other bill we're going to be discussing in a few minutes is probably better suited to accomplish those goals. But I did want to touch on a couple of points that were raised today in the meeting, just again, very quickly. This distinction between active units and approved units. You heard a little bit about the analogy of a horse in terms of taking 3 years to go from inception to racing. a lot of the projects that our company is doing have extremely long time horizons, especially these border locations. Truly, Swan Ranch from inception to opening was almost 2.5 years. We couldn't have done that first step as part of the process without knowing that we had approval for a certain amount of amenities as well as HHR units. As we think ahead, the property has been very successful in achieving its objective and bringing close to 80% of the business from out of state, which is what it was designed to do. Tourism dollars, taxation from Colorado and Nebraska citizens. The whole process that we went through at Swan Ranch was really done hand in hand with both city and county. And in terms of this notion that these approved units will never be used, it's just not true. We are doing a very thoughtful, I'll say financially responsible approach to both our touristic projects, in that we are doing these in phases. As Swan Ranch is, I think Executive Director Laramendi commented, phase one is done. We're already now working on phase two, and we've talked to both county and city to get input. And as part of that process, we're going to be developing other amenities that were not originally considered, and non-gaming amenities as well. So as we go through this process, having those approved units on the shelf, so to speak, allows us to do these things. The sad part is, of course, it's a multi-year process as we go ahead. So we would just ask, that you consider the ramifications of constricting the units as it relates to future planning. And candidly, the city and Cheyenne and obviously Laramie County were very involved as we developed our master plan for that site. I'd say the same thing about our Evanston touristic property in Uinta County. We went through the same process. We met with the stakeholders, had extensive conversations. Everyone understands we're doing this in phases and appreciates the reasons for that. So that, for us, that's part of the reason why there's such a disparity here, is that we wanted to explain exactly what we're doing, what the long-term plan was, and now we're executing those plans. Two other comments, just again, very quickly. I did want to just comment on the distinction between an owned and leased racetrack. Candidly, I think it's semantics, because for us, we have a very long-term relationship and long-term contract with our track in Sweetwater. The lease payment is the tiny fraction of the money that we pay and cover at that location. We invest millions and millions of dollars at that track, not because we have to, because we want to. We're elevating horse racing. We've built a number of new facilities on the grounds, and we've done that in collaboration with the county and Sweetwater, as well as the events complex. And the benefit of that investment is it gets used all year long, not just for our event. And that was the other part of this that we're pretty proud about. As we've been making improvements, we're actually creating our revenue opportunities for the county. Last thing I know, I'm going, it was just to touch about this concept of saturation in terms of the gaming study. If you read through the study, the study really talks about two types of activity. One is inside the state and the other is on the borders. It's clear that inside the state is becoming, I'll say, saturated, and understand that. And that's why we obviously have chosen a long time ago to develop the opportunity on the borders. The Spectrum study really talks about the growth opportunity and revenue for the state really being on the borders. So as we think about saturation, we don't disagree with the study that inside is probably close to, if not at, that point, but we do believe there's opportunity on the borders. So with that, I thank you for taking some additional comments today. I know it's been a long day. I'm happy to answer any questions that there may be.
Yeah, thank you.
Mr. Chairman.
Yeah, I was going to bring you in there, Troy. Senator McEwen, please comment.
So in your estimation, is the lease payment the same as if you were buying the land yourself? And I have a follow-up.
Chairman Kolb, to Senator McEwen, I think we've never thought about that in terms of one versus the other, but I suspect you could equate it that way, that we're essentially it's a mortgage payment to buy the land. But from our standpoint, the lease payment is a relatively small piece of the bigger picture of capital investment and improve of the track. That's really where we've been focused on. What can we do to drive business to the facility overall, and what improvements can we make to have the track be usable all year long?
Follow up?
Thank you, Mr. Chairman. So you're saying the lease and versus a private business buying a track is equivalent. Do I understand that correctly?
Well, what I'm saying, Senator, is again, Chairman Kolb, Senator McEwen, what I'm saying for our arrangement that we have with the Sweetwater Events Complex, to us is much like we own the track, meaning, yes, there's a small lease payment. It's not small, it's a six-figure number. But beyond that, we've invested millions beyond that as part of our long-term commitment to the facility, because we know in the long run it'll pay off. So I think you think about initial investment to build a brand new track versus what we're doing over a series of years. I think in the end, when you look over 15 years or 20 years, probably going to end up being the same in terms of investment. Just one's done up front and one's done over time.
Thank you, Mr. Chairman.
Yeah, thank you, Senator McEwen. Further questions? So Representative Johnson.
Thank you, Mr. Chairman. I would just like to know, you're paying six figures to the track owner. Do you pay taxes on that, county taxes? I'm just wondering if you have an unfair advantage to the operators that do own their own properties.
Right. Chairman Kolb, Representative Johnson, we pay the Sweetwater Events Complex, which is owned by Sweetwater County. So I'm sure that the pro rata share of property taxes, if it were to be paid, was calculated as part of the lease payment. And obviously, in addition to that, we obviously pay property tax on all of the fixed assets that we've invested at the property. That we do pay.
Follow up, please.
Yeah, follow up.
If you amortized, if you actually bought that property, you would be paying a mortgage plus property taxes. Is that correct? I mean, let me get this through my head that you're not paying property taxes. You're including that in the lease payment. I was thinking if that lease payment were a mortgage, you would also have to pay property taxes. Is that correct?
Yes, I think we are paying property taxes indirectly through the lease payment.
Yeah, and to help out with the Sweetwater situation, because I'm a bit familiar with it, there's been nobody ever in the history of that county that said, hey, we want another racetrack, because they're a multi-million-dollar operation to put in. So the events complex has the land, basically, because it was a cooperative deal with the city of Rock Springs years ago, and they've built it out. But there's been I wish there was a private company willing to do it. That would be a better outcome, but there's not. And not to say everyone's going to invest in that in Sweetwater County in that manner. I mean, you're talking about a huge thing, and the locality and the area and the water and so on and so forth. That's the way it's been for a very long time. Just to maybe put some color to that question. Senator McEwen.
One last quick one, sorry. So you're promoting horse racing, yet in Cheyenne, you bought the HHR facility and not the track when you had the chance. So I'm curious what your thoughts on that are.
Chairman Kolb, Senator McEwen, when we purchased Wyoming Horse Racing, there was already an existing relationship with Sweetwater, the complex. There was no track to buy, at least that I can recall, in Cheyenne. But as we went through our thought process, we liked the opportunity that we saw in Sweetwater, and we thought it was worth, investing the money we have in that facility. And candidly, because of our long-term relationship, we're going to continue to do that.
Thank you.
Thank you, Mr. Chairman.
I'll follow up. Okay, further questions? Task Force? Not seeing any. Thank you for your testimony.
Thank you, everyone.
Who else is online?
Nick Hughes.
Oh, can you bring in Nick Hughes online?
I'm here. I apologize for not being there in person. Mr. Chairman, Senators, Representatives, we've listened to a lot of different conversations about the same subjects, but there are obviously conflicting opinions. I don't feel like there's any necessity for me to take up more of your time.
Nick, hold on a second. Introduce yourself, please, who you represent and your full name.
I apologize. It's Nick Hughes. I'm the president of Pacesetter Racing and Gaming, which is the parent company of Wyoming Horse Racing. I apologize. I'm sorry. But yeah, basically, I think my two partners, Eugene Joyce and Pete Ligori, have, explained things rather well, and I don't think I can add anything more without taking up more of your precious time.
Well, yeah, we have a couple of questions. Nick. Number one, do you support this bill or not support this bill? That'd be the first one. And then Co-Chair Line has a question also for you.
We do not support the bill.
Thank you, Mr. Chairman. Thank you, Mr. Hughes, for appearing today. It's my understanding that through your company, you may be involved in some racing in Kentucky. Is that correct?
I was one of the owners of Kentucky Downs that brought HHR to the racing industry and revitalized the racing industry in Kentucky, that although it's the signature industry and most people think it's urban, it's not, it's horse racing. 9 out of the 9 tracks, at least 6 were due to close. 2 of the bigger tracks, obviously being Churchill Downs and Keeneland, would never close, but the majority of the others were on the verge of closure. All those tracks are now fully operating and fully supporting a very, very great horse racing industry in Kentucky. Exactly the same as HHR has done for the racing industry through the Joyce family in Wyoming.
Follow
up.
Thank you, sir, for that clarification. My question would be regarding HHR machines and caps in Kentucky. Can you speak to how many machines are in Kentucky that kept a vital race industry alive?
I wish I could, and it's significant. It is very significant. But we sold our shares in Kentucky Downs back in 2017. So what the current number is, I'm not sure, but I think Pete Ligori may have that number on one of his stats, the current one, because we've been looking at Pete's been doing a lot of analysis of other states and the treatment of HHR in those states. If I had to take a guess, it's probably at least 3 times to 5 times more than it exists today, easily, that exists today in Wyoming. But I don't know, but Pete, do you have that number?
Thank you, sir.
Thank you. Sir, would you have some light on this subject?
Kyle Ridgway, Wyoming president of Wyoming Downs and 307 Horse Racing. I'm with Wyoming Financial Group and 307 First. Our partners are the current ownership at Kentucky Downs and have that racetrack and facility. I'm intimately involved with what the existing status is in Kentucky. I was just at the Kentucky Downs race meet this last weekend for 4 days. There are a significant number more than in Wyoming. Just the Mint Gaming Hall at Kentucky Downs alone has over 2,000 machines at that single facility. I don't have the exact number, but I would agree with Mr. Hughes that it is 3 to 5 times is probably about right. I think it's probably close to 10,000. What I do know is that there is no statutory cap on machine count in Kentucky. I do know that for a fact. Thank you.
Thank you for your testimony. Any other further questions? Task force? Nope. Seeing none. Thank you for your testimony. Anything else online would you like us to know? No? You're off? Okay, good. I guess thank you for your comments. And we're moving on. Anyone else in the audience wish to come up and testify? Okay, seeing none. We'll close public comment. I'm going to make a comment that we do not have time to work this bill fully. I think we're going to go up to 5 o'clock. We're going to do what we can do, and we're going to have to go for another meeting because there's a lot to this. And we haven't even got to the next bill yet. So we've got a few things open. I think it doesn't do it justice because of the complexity of this subject in the amendments that could be coming up, that we're not going to have time. We're not going to get this thing rolled out in 15 minutes. Just won't happen. We're going to lose a member here, and all of us have to probably go somewhere else later on today. So I think we're going to call this at 5 o'clock. We're going to do what we can do today, and then we're going to have to continue on. There's been a request by Management Council for an extra day, to be clear, probably because there's always something to do about this topic. And this is just the tip of the iceberg. So we'll continue as that closes public comment on this proposed bill draft. Task Force, what is your pleasure? Yeah, you have to move the bill.
Move the bill.
Okay, is there a second? And there's a second. All right, the bill's been moved and seconded. Task Force, what would you propose at this point in time on this bill, if anything? Thank you. Co-Chair Line.
Mr. Chairman, I move that on page 4, lines 11 and 12, that we strike "or other parimutuel event day."
All right, is there a second for that?
I'll second it.
All right, it's been moved and seconded. Discussion. Co-Chair Line.
Mr. Chairman, I believe that we heard the testimony about things such as rodeos and giving them the authority to have the HHR machines when they don't have a live track. So this is just the suggestion of the Gaming Commission.
All right. Further comments? Seeing none, all those in favor of the amendment, please indicate by saying aye.
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 All those opposed? The amendment passes. Next, further discussion on this bill draft. Co-Chairman Line.
Thank you, Mr. Chairman. I would move that we go to page 6 and strike lines 19 to 23 and at the top of 7, 1 through 5, and just remove section C altogether. That way, when zoning, the city, towns, and authorities that have, they already have built-in fail-safes within their zoning when it comes to, I guess I need a second before I give you a reason why.
Well, yeah, restate your motion. I think that's probably in order.
Mr. Chairman, I move that we strike at the bottom of page 6 and the top of page 7 from 19 to 23 and 1 to 5 to remove section C from the bill.
So you want to strike section C?
Yes.
Okay, cleaner way of saying it. Okay, striking section C. Do we have a second?
I'll second it.
Been moved and seconded by 2 seconds. Further discussion on this amendment?
Mr.
Co-Chair
Chairman,
Line.
I believe that we already have a fail-safe built into our zoning regulations that are non-conforming use, vested permits, grandfather clauses, and that our local municipalities and counties and towns could use those that are, don't need to be labeled out specifically in legislation. And if they chose to go through an amortization process, that they at the local level could figure that out versus the state mandating it.
All right, further discussion? Seeing no further discussion, all of those in favor of this proposed amendment signify by saying aye.
Aye.
Those opposed, no. Aye. Amendment still, it passes. Further amendments.
Mr. Chairman, Tamara Revley over here.
Oh, Tamara?
I might just clarify that I would interpret this as a conforming amendment, that the provision on page 7, line 16, would not need to be included. So that would remove all of line 7 through 23 on page 7 and page 8, the top 1 and 2.
So to be clear, it's page 7, line 7 to page 8, line 2. Well, hold on a second, let's take a chance to read this. Conforming amendment. Well, LSO says it's a required conforming amendment. Further discussion. All those in favor indicate, well, I guess we have to have a motion for the amendment. We had a suggestion. Senator Craigo?
Mr. Chairman, I think you can just confirm that it's a conforming amendment, which it is.
Well, I confirm, and that's the end of that? Okay, well, let's move on then.
Mr. Chairman.
Chairman Lynn?
Thank you. We were handed this piece of paper, and I'm just intrigued to have a conversation with the committee about leasing devices among operators, and if that should be amended or if it needs more thought coming into the next meeting. I'm going to assume there's going to be a next meeting.
Yeah, Co-Chair, I think we have to be very careful, because if we start doing too many things, this will go in the trash can. It will go nowhere. So I think on this, I mean, number one, I didn't receive this before the meeting, so it's all new. So I think it's only fair to let this task force consider this language on the next meeting, and I do believe there's going to be a next meeting. It's the only reason why I'm saying this right now. I think, I'm pretty assured there will be. So I think this has to be studied and carefully considered, so we don't end up killing a bill, because that's very well what's our history, or not our history, but I don't want to repeat other people's history. I'll just say it that way. That makes sense, Co-Chair? Committee, you good with that? Okay. All right. Next, any other further amendments? I think then, at this point in time, Co-Chair, we should put this off to our next meeting and put it on the agenda, as with the second other bill for local control for the next meeting agenda. And you certainly can. So that's just a preface for what I think we need to do at this point in time, because we're out of time, but you're certainly, anyone can make a statement. Go ahead, Co-Chair Line.
Thank you, Mr. Chairman. Just a little bit of a statement about this legislation, and the direction that I think we're moving in is a good one. And I know that we keep being told that zoning won't work, but I heard very emotionally from one that had the opportunity to go through the zoning process, and all the effort and time that it took to get the property up to value, up to the zoning requirements, as far as changing driveways even. And so that tells me the zoning is doing a job. The permitting process is up to the Wyoming Gaming Commission when it comes to revoking permits and saying who can have these permits and who cannot have them. We also learned today about zoning, that zoning determines how, when, and where it is to occur for the welfare, safety, and health of the people. In Virginia, they have 8.1 million people and a cap of 5,000 machines. Wyoming, we have 580, 560,000 people, and here we are well over 500,000 machines, or 5,000 machines, excuse me. So my concern would be, where does that balance happen? I hear talk about population-based. Well, I'm not going to consider population from Colorado coming into Wyoming for Laramie County. If we're talking about a population-based liquor license, we don't consider how many Coloradans come here. So therein lies, how many machines can Laramie County hold? How many machines can Uinta County hold? I think that there's a real drive here with zoning to make a difference. We already have laws established for change of use permits, vested permits, grandfather clauses that will protect the property rights that are already in place, and for any zoning changes that need to occur. I really believe that this intent of HHR machines was for live horse racing, and I want to see that succeed. The caps, I still am firm at 1,200 machines, but I know that I'm one vote of many, and so there's a conversation to be had there. So I agree with the co-chair that this needs to be moved to another meeting. There's still conversations to be had, but I do believe that it's moving in the right direction to give our local control truly to municipalities and counties on the same playing field.
Senator Craico.
Thank you, Mr. Chairman. So just a little bit of a response to that. So if your county has zoning, then yes, you get local control. A little bit, not a lot, you get a little. If your county is like mine, which doesn't have zoning, you get zero. You get zero say in the process whatsoever, according to this bill draft. So I get to go home and tell my county that they don't have any control. I've just voted to take away any control they had. At least now they get a say under current statute. Moving forward, if this is the bill we were to pass, they get none because they don't have zoning. And then the only way for them to get control would be to institute zoning, which is never likely to happen in my lifetime in my county. And so it works for some counties, it doesn't work for all of them. And so we all represent different interests, different places. Just pointing that out as we have this discussion, that this doesn't create local control for everywhere in Wyoming.
Thank you, Senator Craigo. I got one thing to say, if I could, and you can talk, co-chair mine. I guess we'll go by how many times I've spoken now. My problem with this bill draft is pretty simple. It doesn't take care of the current issue we have, because all the current people that are licensed will continue to be licensed because of the taking issue, okay? And being we've already had testimony that we are saturated, this doesn't do much. But I do think there's parts of this bill which I like a lot. I like frankly, the number of machines deserves a conversation, and also not having these permitted machines in perpetuity deserves a conversation. I think those are valuable points to pull out of this, at the very least. So I'm not opposed to this bill entirely, but I think for what we're trying to do, I'm concerned that frankly, it's a big lift and it's top heavy and it's probably gonna fall in the garbage can. And I don't want that to happen, because if we don't come up with something for local control, no matter what we can agree to, we still don't have local control. And that's what my goal is. We need to get there, and we gotta get there by working together, because with the House and the Senate, if we disagree, we're dead in the water. So we got to figure out probably a compromise in talking about this. So I'd ask the task force to keep an open mind, and we'll try to work on this to sew together a package that we can work with together as a body, and get something forward to give our people in the state of Wyoming local control, which I still attest they don't have. I want to do that, and I'm willing to learn different ways of doing that, but I have some concerns about this, and with that, I'll cease my comment. And Co-Chair Line, you had a comment?
Thank you, Mr. Chairman. I just want to remind the committee that parimutuel wagering is all based on voting. Our voters have to say our counties want it, and therefore lies the most local control with our voters.
We could probably go back and forth a while on that one. And I wish they voted on the current form of gaming that we have, co-chair. I think we pointed that out as a shortfall and one of many things we could talk about into the future. But with that, task force will take this up on our next meeting. I thank you for all your participation and time and effort, because everyone's finding out this is a big lift and it's going to take a lot of group effort. So with that, I'll call this meeting adjourned.